1st, 2022. This is the Senate Judiciary and Public Safety Committee. For the record, we do have quorum. Today's agenda includes two bills, Senate File 2673, which is the Senate's Public Safety Omnibus Bill carried by Senator Limmer. And Senate File 3329, that's my bill that we heard last week, but we laid it over. This hearing will include committee action and a final vote on both bills. No additional public testimony will be taken during this hearing. It looks like we have several amendments today. So let's get started. We'll start with the A35, an amendment from Senator Limmer. It should already be in your packets, members, and we will take that up now.
Mr. Chairman, before we get into the A35 amendment, I'd like to address the spending issue in this bill. In the course of the last few days and weeks, we've had inquiries about the spending dollar amount on the bottom line on this bill. Just like to explain that. I don't think I've had much of an opportunity to explain it. Our leadership gave our committee, namely me, the ability to establish the budget as we saw fit. Once that was created, it was $199.4 million. We arrived at that, built the bill around that dollar amount, and as a result, leadership has rounded that up to $200 million. So there's a little slop room there, but I want to hold that in reserve. We're waiting for a rape kit fiscal note, and I know that was a concern of Senator Bigham as well as myself, and so I'm holding that in flux right now, but since leadership has rounded it to that $200 million amount, we should consider it a spending limit. So now I'll move on to the A35 amendment, Mr. Chair. Mr. Chair, the A35 amendment recognizes a few things. There's a few amendments in a combination here. The first one, lines 1.3 to 1.5, defines a report element that we would like to have. This is in regards to the Ramsey County Public Safety Grants, and it simply means that the report must identify instances in which a portion of the money was used to reimburse or directly compensate peace officers from other jurisdictions. We'd like to specify this by agency and dollar amount. That was a recommendation or a request by Mr. Neumeister for reporting purposes. Going down on lines 1.7 through 1.15, we're requesting a little more definition on some of the monies that might go to law enforcement to make sure that it wouldn't be supplanted in their salaries, but that it would be in addition to salaries, and we're just making clear that that's what the legislative intent would be. Going on to Section 14, that is technical from Senate Council to ensure language works the way we intend, and that judges must execute prison sentences in these cases. I don't know if council needs to talk any more on that. If there is a question, I'm sure council could answer. The others are basically technical, I believe. Mr. Backus, would you agree with sections 15, 16?
Mr. Backus?
Mr. Chair, members.
Push F1.
Yeah, sorry about that. Mr. Chair, members. Yeah, sections 14 through 16 delete the provisions in the delete everything amendment that were originally there. These are the provisions from Senator Newman's bill amending section 609.1095. The original language was a little confusing and didn't technically require a judge to execute the sentence. The intent of the bill was to require that for these types of offenders, and there was a little bit of a loophole in the bill, so this closes that, consistent with the author's intent.
Thank you, Mr. Backus. Senator Limmer.
I think that concludes my explanation.
Senator Bingham.
Mr. Chair, I move the A35 amendment.
Thank you, Senator Limmer. Senator Bingham? Oh, okay. I took you literally. All right. Any discussion? All right. Members will vote on that. All those in favor of the A35 amendment, say aye.
Aye.
Aye. All opposed? Amendment passes. Now, Senator Bingham.
Thank you, Mr. Chair. I would offer the A43 Amendment.
Senator Bingham offers the A43 amendment. To-your amendment.
Thank you. This is the amendment for unified billing for rape kits. In your packet that Chair Limmer was mentioning, in your packet, you will see a letter of support from MNCASA and also the Sheriff's Association. So I introduced this bill and then asked Senator Benson to chief author it because I figured it might have a better shot at getting through. And it's something that we've worked on before, some of these issues before together. What's happening, members, when I met with my Cleos before session, the sheriffs really were getting bills that were all over the place in the amounts. It's hard to budget for that. And then when I dug deeper into this, I met with an incredible group of women, the SANE nurses, which are the sex assault nurse examiners, and I heard horrific stories about victims of sexual assault being billed for their own rape kit, and problems with getting bills taken care of as well, and the trauma that ensures on a victim is just disgusting. And so what this bill would do is dedicate $5 million, and it is, as Chair Limmer said, it's just kind of a placeholder because Mr. Turner and I and Senator Benson have worked really hard with the department to try and get a fiscal note. It's just not ready yet. And so simply put, this would have the department, OJP, Department of Public Safety, OJP, get money to handle the billing of the rape kits. And this will give continuity to our sheriffs, local law enforcement, but also ensure that victims of sexual assault don't have to be re-traumatized on an issue of billing, which is just unbelievable that that's happening. So I would hope I could get support from the committee on this to move this forward to the Finance Committee where or Chair Limmer and Senator Benson can fine tune.
All right. Thank you, Senator Bingham. Senator Limmer.
Thank you, Mr. Chair. I have a question for Mr. Turner. Mr. Turner, have we gotten any fiscal note regarding rape kits yet?
Mr. Turner.
Mr. Chairman, no. Not for the lack of trying, though. The LBO has been in contact with DPS, and they know our schedule. It was due today, so technically it's not late. But we should be able to get it. DPS should be able to get us a number by Tuesday when the bill goes to Finance.
Mr. Chair.
Thank you. Senator Bingham.
Chair Limmer, what I have done with the help of MNCASA, how I'm getting to the ballpark of $5 million, and I apologize, I should have dug a little deeper into that. The average price is about $1,400 per kit. And so if you take that times the number of kits that are done, and then OJP will need staff. And so that's where we're coming up with the near $5 million. But again, I'm acknowledging that this is a financial placeholder and that you and Senator Benson would be able to fine tune that.
Thank you, Senator Bingham. I think what Mr. Turner was saying is if we can drag out committee to like 5 or 6 tonight, maybe we can get that note.
Oh, we're going to leave early?
Senator Limmer.
My question would be, since we don't have it, I have a suggestion. Either we could hold this for later, or we could remove the dollar amount, have it a blank, that'd be a placeholder, and then we could wait for the fiscal note to come to us. And then we can discuss dollar amount then.
Mr. Chair.
Senator Bingham.
Chair Limmer, I would prefer to then zero out the fiscal note and have you and Senator Benson fill it in later on down the line.
Yeah.
So then, Mr. Chair, I would need to do an oral amendment to my amendment to delete line 1, everything prior to, on line 1.6, up to the word is and insert zeros. Am I not right? That's how we would kind of do that, delete the 5 million from it? Or put the word blank?
No, just blank.
Just blank?
Right. Why don't we go to Mr. Backus then for the official legal edit on that, please?
Mr. Chair, members, on line 1.6, delete 5 million and insert a blank line.
That's my motion, and giving him the ability to have any technical changes he needs on it.
Perfect. On that motion,
Mr. Chair, on this motion, on the dollar amount, if we don't have a fiscal note, why are we putting in a dollar amount? Is it a placeholder?
Senator Bingham.
Yeah, Mr. Chair, Senator Kiffmeyer, yes, that's what Senator Limmer
Yeah.
had suggested.
Well, we have our 200 million. I think this puts us over the 200 if we do this. And since it's a placeholder, let's just lower it so that it can be within the 200.
Mr. Chair, Senator Kiffmeyer, that's what we're doing. We're zeroing out the 5 million so that there's no fiscal impact on the money that Senator, or that Chair Limmer had mentioned. That's what we're doing.
Okay,
Senator Kiffmeyer?
well, so then Senator Limmer is okay with this?
Correct.
All right, then we're good.
Any further discussion? Seeing no further discussion, Senator Bingham?
I'll renew my motion to amend my amendment.
Okay. All those in favor, say aye.
Aye.
All opposed? Motion passes.
Mr. Chair, I'll renew my motion to add the A43 Amendment as amended.
Any further discussion?
Mr. Chair, what is the number that we have on the bill that is amended?
It'll be A43. Senator Anderson.
With blank appropriation. With blank appropriation.
With a blank appropriation, correct.
Mr. Chair, I'll renew my motion to support the A43 Amendment as amended.
Senator Bingham renews her motion. All those in favor, say aye.
Aye.
Aye. Opposed? Motion passes. The A43 amendment is adopted.
Thank you.
All right. Any further discussion? I'm sorry. Senator Pappas.
Thank you, Mr. Chairman and members. There's so many, I have to unmute. There's so many wires and files. Sorry, there's so many technology here. I'm afraid I'm going to spill my tea, too.
You know how to make an entrance, Senator Pappas.
Mr. Chairman, I have the A41 Amendment. Start with this one.
Senator Pappas introduced the A41 amendment. Senator Pappas, to your amendment.
Mr. Chairman, this is similar to the Bingham Amendment in that whereas this is direct assistance to crime victim survivors, And whereas the 12.5 million is, was the requested amount, I would like to just change that to 500,000 so that we have it as a placeholder, or blank if the chair prefers. So crime victim services grants is something we've done over many years, and this is an increase, and it's being requested by 6 crime victim coalitions as an increase to their base, and it includes, the money would go to the Office of Justice Programs, and it would fund organizations like Violence Free Minnesota, the Minnesota Coalition Against Sexual Assault, the Minnesota Indian Women's Sexual Assault Coalition, the Minnesota Alliance on Crime, Mending the Sacred Hoop Coalition, and the Minnesota Children's Alliance. And they represent over 200 programs and individuals providing services and advocacy to victims of domestic violence, sexual assault, child abuse, and general crime across the state of Minnesota. Crime victim services have not received an increase in base level state funding in over 7 years. And it's important that we provide sustained government funding to provide critical public safety services to victims of crime. And certainly during this time period when we are seeing a crime wave, it's even more important for us to be supporting the victims. Thank you, Mr. Chairman.
Thank you, Senator Pappas. Senator Limmer.
Mr. Chairman, I have another question for Mr. Turner.
Mr. Turner.
Mr. Turner, do we have existing funds going to these organizations currently?
Mr. Turner.
Mr. Chairman, I believe that these organizations are getting money right now from the Office of Justice Programs through the sexual assault grant program there. I don't have a detailed list, but dozens of organizations receive money currently in the OJP base. I guess I don't know if all of these do, but I'm pretty sure that like MnCASA does, probably Minnesota Alliance on Crime. But yes, it's rolled up into the OJP base.
Mr. Chairman.
Senator Limmer.
Senator Pappas, I believe this would be more of an appropriation that would be more timely for the regular budget that we do at the beginning of each biennium. And due to the fact that we do have a limited spending limit, I'll have to oppose your amendment.
Senator Pappas.
Mr. Chairman, just a brief comment. I think it's very hard for the public to understand this and for especially victims of crime to understand the limited funding. All they know is we have a $9 billion surplus and feel like they're providing really important services throughout the state to crime victims. And as I mentioned earlier, we have been experiencing a crime wave. Sexual assault doesn't go away, domestic violence doesn't go away. We've not been able to make any inroads in reducing crime, especially in recent years. So like I said, they haven't received an increase during the regular budget year, and we often do provide increases in supplemental budgets. So, Mr. Chairman, I would just urge you to reconsider and at least pass this on as a placeholder to further negotiation should your budget grow bigger. And I'm happy to incorporate into my amendment to delete the $12,500,000 and just insert $500,000.
So did you move for $500,000 then?
Yes.
Okay. All right. Members, any comment on that discussion?
Mr. Chairman, are we amending the amendment or are we voting on the amendment?
We are amending the amendment from $12,500,000 to
$500,000 on line 1.6.
Mr. Chairman, you probably want to amend line 1.18 to the base of the activity is 500,000 fiscal year 24 and thereafter.
Okay.
Okay.
So we'll incorporate deleting that last sentence.
Senator Pappas, you want to delete 8,500,000 out of that last sentence?
Yeah, I believe Mr. Turner was pointing that out as Mr. Backus was talking to me,
Okay.
that we need to take that out.
All right. Mr. Turner?
Mr. Chairman, so if we delete that sentence, yes.
So take away the basic funding that we have in
Okay,
place
but-
right now.
If the amendment is silent, it's ongoing.
Okay.
So delete the last sentence, is that what you?
Yeah, as long as the base funding continues.
Any discussion on the amendment to the amendment? Seeing none, all those in favor of the amendment to the amendment, say aye.
Aye.
All opposed? No. Amendment fails. To the amendment.
Well, Mr. Chairman, then we're back to the original bill, which is 12.5 million. So then I'll just move that A41, the original amendment, be adopted.
Senator Pappas moves the A41. Any discussion? Senator Anderson? Has not been amended. The amendment as introduced here. The amendment as introduced.
I tried to do that. in the amendment.
See no further discussion?
Mr. Chairman,
Senator
just
Senator
one correction. Typically, it is common for an author to be able to just incorporate a change into their amendment and not amend the amendment, as I know Senator Bigham did. So I would just like to request that be the vote again, that I be allowed to incorporate the change to delete 12,500,000, insert 500,000, and delete the last sentence on 117 and 1.18.
Okay. So Senator Pappas, I haven't seen that before, but if that is pattern practice of the committee, then sure they want to make sure we follow that. So
I'd appreciate that, Mr. Chairman.
very good. So on line 1.6, it would read 500,000 is awarded to grants.
Correct.
And then on 1.17, it would delete everything following the period.
Correct. And delete 1.18.
1.18. Very good. Members clear on that?
Mr. Chairman,
Senator Limmer.
I have a question just on process. We already are on record voting against reducing the dollar amount down to $500,000. And now the author wants to verbally incorporate the 500 million into the amendment, even though the committee has already voted against that. So we're getting two bites at the apple here.
And that may be my mistake. Mr. Backus, would you be able to speak just on the procedure on this?
Mr. Chair, members, at least to the Senator Pappas's initial point, there's no, that I'm aware of, rule on this. It's really custom and practice. And I think generally speaking, it's true that authors can incorporate changes before the amendment is made without amending it technically. Again, I don't know that that's in any way mandatory, but it seems to be the way we've usually done things. Does that help?
It does. Thank you. Okay, so on this point, because we have revisited, let's continue with the incorporation of the amendment that's in there, and then going forward, I'll remember that going forward. Any further discussion on the amended amendment?
Yeah, what exactly are we voting on, Mr. Chairman?
We are voting on, so this would be the A41 Amendment with the proposed change that Senator Pappas has brought forward, reducing 6 on line 1.6 to 500,000 instead of 12,500,000. And deleting everything following on 1.17, the period, the base for this activity, and then 1.18 would be completely deleted as well.
Thank you, Mr. Chairman.
All right.
Mr. Chair.
Senator Ingebretson.
Mr. Chair, before we vote on the amendment, I'm asking the chair if money can be moved around. Maybe that would be helpful in future amendments if 500 be pulled from someplace else. Is that the intention of the chair?
Senator Ingebretson, I think I'll pass that on to Mr. Turner or Senator Limmer.
Thank you, Mr. Chair. Senator Ingebretson, I suppose that's possible as an amendment. However, it devil's in the details of where the money's going to come from.
Right.
So that's always an option by any committee member.
Mr. Chairman.
Thank you, Mr. Chair.
Senator Latz.
To that point, it was made pretty clear in this committee earlier this week that we have not been given a target, that there's no official target here. In fact, that leadership is not giving targets to committees. So that means that we are under no formal cap on the amount of money that can be spent in this bill. I mean, even if there had been a target, technically, I think the targets to committees are informal. They're not formally binding. They are binding on the floor once the bill gets there. But we're not even, don't even have a target. We haven't been told $200 million is what you're allowed to spend. There's been no public leadership statement to that effect. There's been no committee leadership statement to that effect. So the best information I gather is that there's sort of an anticipated goal or range. So I think that leaves it within this committee's discretion whether we want to go above the dollar amount that's in the existing proposed A5, Senate File 2673 in front of us with any amendments. So I don't think we should feel ourselves bound by anything. I think we should determine the individual amendments on their own merits. Now, I think maybe what we'll find is if the committee is going to start voting down amendments just because there's some artificially described, informally identified in people's minds cap on how much we can spend, well, we can take an alternative path each time, I suppose, and start pulling money out of other parts of the bill. And we're going to probably double the length of this hearing as we start to figure out where we're going to do that from and have amendments drafted accordingly. But I would respectfully suggest with a $9 billion surplus that, you know, we're noodling around in the millions here, which is in the 1%, you know, 1% range. Actually, do the math. I should get our math person here. Much smaller fraction of that. What's 1 million as a percent of 10 billion? 1/10 of a percent or something like that? Or 1/100th of a percent? I mean, we can, I suggest we make these decisions sort of on the merits, what we think is appropriate to fund these programs. And then this is going to finance, and if there are finance restrictions imposed on these things, then I guess it'll sort itself out in the process. But at least we can be on record saying we think it's appropriate that this program deserves to have a certain level of funding. I think that's an important statement for this kind of a committee to make as well. Thank you, Mr. Chairman.
Thank you, Senator Latz.
Mr. Chairman.
Senator Limmer.
Senator Latz, you may have missed my opening comment. Before we even got to the A35 amendment, the very first one, I made a statement regarding the finance limit. This year, our leadership gave us a little different direction. They relied on chairs to set a budget for their area. In that case, the budget that we had is in front of you, $199 million, $0.4 million. Leadership considered that. They added a little bit. They rounded it up to $200 million. And they told me to consider that a spending limit. So I want to abide by that limit, Senator Latz.
No. Mr. Chairman, I guess I was too busy organizing my amendments to, I didn't catch that opening part of your statement. Senator Limmer, I think that's an artificially low limit, and every budget decision we make is a policy decision, and it's a choice between values. I guess we can express our values as a committee, whether we support spending in certain areas or not. And that will be the outcome of whatever decisions we make. So I guess we'll take it step by step then. Thank you, Mr. Chairman.
Thank you, Senator Latz. We'll go back to the A41 Pappas Amendment as amended. Any further discussion on that? Seeing none, all those in favor of the A41 Amendment indicate by saying aye. Aye. All opposed?
No.
Nay. Amendment fails. Back to the A35. Any further comment, discussion? Senator Latz.
Mr. Chairman, I have the A45 Amendment.
Senator Latz offers the A45 Amendment. Senator Latz.
Mr. Chairman, the A45 Amendment requires that law enforcement officers in a law enforcement agency retain recordings for a minimum period of time. It refers to particular recordings and it specifies the amount of time. In this amendment, it requires that any video or audio recording made of a person during a custodial interview, a booking, or implied consent or breath testing procedure be retained for at least 60 days from the date of recording or until all criminal proceedings relating to the person recorded are complete, whichever period is longer. The reason for this amendment is a recent letter that a legal colleague of mine received from a prosecuting attorney stating that if there are detention or implied consent videos, they are only available 30 days from the date of the offense, which seems to imply pretty strongly that those videos are destroyed or deleted, those recordings are deleted from their systems after 30 days. Well, as a practical matter, that really makes it difficult, I would think, for the prosecution or for the defense to be able to evaluate some of the facts in the case. From an implied consent standpoint, the petition to challenge the implied consent driver's license revocation isn't even due until within 60 days of the date of the service of revocation, or the notice of revocation. Sometimes criminal charges aren't even brought right away before someone is released from custody. They may be held and released pending charges. And in some jurisdictions, those charges in the form of complaints get into a backlog in private attorneys' prosecuting attorneys' offices, and could be more than 60 days, certainly more than 30 days before the complaint is even filed. So the defense would not even necessarily know if they were facing criminal charges, while evidence that may be relevant to the defense, or from that standpoint, the prosecution, might be destroyed in the meantime. So 30 days is a really short retention period for these things. And hence the proposal here. It's narrowly tailored, so it's not applying to all recordings in a jail facility, for example, because, they got lots of cameras, they're going all the time, and not everything that's going on in a jail is relevant to any constitutional rights, theoretically even. So I've focused in on custodial interviews, booking, and implied consent and breath testing proceedings. And I think 60 days should be enough. Candidly, I've found, we changed a number of years ago, we changed the filing deadline for implied consent plate impoundment petitions to 60 days instead of the 30 they were, matched up with forfeiture. And then with the pandemic, when there was a lot of backlog in the courts and defendants weren't getting into court until 90 or more days after the incident, they were still finding out that they had some rights that they might have been able to exercise that they didn't really realize until after even the 60 days had passed. But that was kind of a practical pandemic problem. Hopefully it's not going to be a long-term problem. So I think 60 days is an appropriate number. I have received feedback from at least some of the law enforcement organizations. I know the Sheriff's Association was at least in principle, I think, okay with this proposal. My understanding is the chiefs were comfortable, but I haven't heard specifically from them. So I'd ask the committee's support for this. I don't think it'll impose any serious hardship. It's just a matter of changing retention deadlines in law enforcement agencies for certain recordings.
Thank you, Senator Latz. Senator Limmer.
Thank you, Mr. Chairman. Question for Senator Latz. I don't mind the spirit of the bill, but Senator Latz, do you have any data on how much the retention cost would be by doubling the expense for retention from 30 days to 60 days for local political subdivisions?
Senator Latz.
Mr. Chairman, I don't have any data on the fiscal cost of leaving the recording in a computer for an additional 30 days. I really don't. We heard testimony here earlier when I raised questions about costs of data storage, and the testimony that we got back was, well, the cost of data storage has really dropped an awful lot. So it's probably not that significant, but in any case, certainly the ability to preserve evidence and the ability to preserve any constitutional issues that might arise in criminal cases, I think would merit the additional 30 days here.
Mm-hmm. Mr. Chair, Senator Latz,
Senator Limmer.
in your discussion with law enforcement people, did they ever bring up a retention cost?
Senator Latz.
Mr. Chairman, Senator Limmer, no.
All right.
Senator
Mr.
Limmer.
Chair, I would accept this as a friendly amendment.
All right. Any further discussion? Senator Bingham.
Mr. Chair, so we're not going to vote on that, you're just going to accept it?
We
Oh.
still have to vote.
We'll
Sorry.
still vote.
Mr. Chair, then I would offer the
It
A42
hasn't
amendment.
been voted.
We're going to vote on that, so, thank you, Senator Bingham. Any further comment? No? All right, all those in favor of the A45 amendment indicate by saying aye.
Aye.
All opposed? Amendment passes. All right, Senator Bingham.
Thank you. I'm going to offer the A42 amendment.
Senator Bingham offers the A42 amendment. Senator Bingham, to your amendment.
Thank you, Mr. Chair. This is a bill that Senator Duckworth and I have been working on. We both have a bill to this. It involves amending the killed in the line of duty statute. Sergeant Corey Slivko died by suicide after suffering from diagnosed PTSD. And what is happening is the workers' comp claim is being denied. And this is traumatic to the survivors, not only his spouse, but his children. In the packet, you will see a letter from his spouse and survivor. And You know, these officers, firefighters, correctional officers, see things that they can't unsee. You know, I've already have said many times I'm the daughter and sister of firefighters, so I know firsthand the struggles that they go through from responses to scenes and to crimes and to fires. So simply put, this allows PTSD to be included in the killed in line of duty for the means of workers' comp, and I actually make it retroactive to January 1st, 2017, so that some of the claims that are in process are included, it can now be included. But also, you know, I will say that when an officer or firefighter is killed in the line of duty, they also are honored, and this is a way for their survivors and family to get the recognition that they deserve, Mr. Chair. So I'm hoping there is no fiscal note to this, and I'm hoping that we can incorporate this in and move this along. And again, I thank Senator Duckworth for his help and advocacy on this. And then also on the federal level, there is efforts being done to do this on a federal level. So with that, I would ask for the committee's support and the chair's support.
Thank you, Senator Bingham. One clarification with the fiscal note. This does not have a fiscal impact, or there just isn't a fiscal note prepared for this?
Mr. Chair, thank you for allowing me to clarify that there is no fiscal impact.
Senator Limmer.
I'm trying to catch up to the amendment, Mr. Chair. Senator Bingham, could you tell me what is your amendment trying to accomplish again? I missed it.
Sure. Mr. Chair.
Senator Bingham.
Mr. Chair and Senator Limmer, right now PTSD is not included in, for workers' comp in a killed in the line of duty for law enforcement, firefighters, correctional officers. And this would allow that if the letter in there from the survivor of officer, the spouse and widow of Officer Salivko allows for PTSD to be a recognized death killed in the line of duty. And they have to have been diagnosed, and it allows for a retroactive impact of January 1st, 2017, because there are a handful of officers that this has tragically happened, and they would then be able to go through that process. And Mr. Chair, one other thing, I have been working with MPPOA on this, and I do know they would appreciate this, and they do support the continuation of it.
Senator Bingham, so by definition, though, by going retroactive, you're dealing with dollars. So I still don't understand how this does not have a fiscal impact. Is it simply there isn't a fiscal impact within the jurisdiction of our committee? Or, you know, because now you're opening up benefits to officers from 2017 and onward with PTSD. So could you just clarify that, please?
Mr. Chair, it would be a workers, it would be a workers' comp claim, not a fiscal impact here. So it would go through the local jurisdictions, Mr. Chair.
Senator Limmer.
Mr. Chair, if we pass this, does that mean that this bill would have to go to Jobs Committee or Health Committee, or I just don't know. It makes mention of mental health providers, retroactivity. They might be interested in that. Does it affect a worker comp fund of some sort if the benefits would be improved and retroactively? I just don't know the fiscal impact on this. I think there would be a fiscal impact, at least to the worker comp fund. if we're going to recognize a new cause for benefit. I'm missing something here.
Senator Limmer, I think the jurisdiction actually of this would be pensions, correct? Senator Bingham? No, Mr. Turner?
Yes, Mr. Chairman, members, I believe that by including suicide in the definition of killed in the line of duty, you're including those families of the suicide to a $100,000 benefit under 299A.44. And then statute continues, 299A.45, eligible persons, their education benefits for surviving children. So, I don't, yes, there would be a fiscal impact if an officer committed suicide under these conditions. I don't know how often that happens. We don't have a fiscal note on it. But, and it's a difficult thing to predict, but this does have fiscal implications.
Thank you, Mr. Turner. Further discussion on the A42 amendment? Senator Limmer.
Mr. Chair, I don't know if, is 299, section 299A.41, is that in our jurisdiction? It is, all right. The only question I have is, I just don't know the impact on this. I'm sympathetic to what you want to do.
Mr. Chair.
And I do always question retroactivity because we try to avoid that as well.
Senator Bingham.
Thank you, Mr. Chair. I would like to keep this moving along, and then in the Finance Committee, obviously I am not in the majority, I'm not on the Finance Committee, and so I would leave it up to you as the representative of this committee on the Finance Committee. But, Mr. Chair, this is important in the way of how we are addressing mental illness that is impacting our law enforcement, firefighters, correctional officers. There are highly publicized events that we have had in here that talk about, and testimony in here that talk to this. And in fact, Mr. Chair, you have $1 million in your budget for this reason. And this is the honor, in my opinion, and that of Senator Duckworth and the co-authors of both of our bills. I would ask that we continue, if we could accept this and we could continue on the discussion and see if there is something that makes you comfortable and the other members of the Finance Committee. I will say this, the retroactive part is important because they deserve the honor that they earned in the sacrifice that they paid, the ultimate sacrifice that they paid. So I'm hoping we can just continue this along into the Finance Committee, and then, Mr. Chair, Senator Duckworth and I would be happy to talk with you, see if we can't iron out any details, and we can meet with them PPOA as well.
Thank you, Senator Bingham. Senator Ingebrigtsen.
Thank you, Mr. Chair, and question to Senator Bingham. I'm sorry I stepped out, but was this a death benefit for post-traumatic stress syndrome diagnosis? Is it like a law enforcement and death benefit? Because I know we've certainly talked about and are now giving disability benefits as well as some medical treatment for this particular illness. But is this a death benefit? I'm sorry, I just didn't catch that.
No.
Senator Bingham.
Thank you, Mr. Chair. No, real quick, Senator Ingebrigtsen, this adds under the killed in the line of duty would result of suicide would also be included now in that for the survivors, and it'd be allowed for a workers' comp. And you'd have to be diagnosed, as the officer would have had to been diagnosed. And so there is, records that would confirm that. And then all it would go retroactive back to 2017 to include officers that this was a result of the ultimate sacrifice.
Mr. Chair?
Senator Ingebretson?
Mr. Chair, I certainly understand the sentiment, and it's been a big deal here lately. And, I'm not so sure that this is going to be something that in the future that's going to be, and hopefully not going to be such a huge thing. And I know there's been talk about benefits. There's been talk about the stress that law enforcement for sure is going through, as well as firemen. However, I think this has a huge fiscal impact moving forward. Mr. Chair, if I might, I don't know if you asked this question either because I had stepped out, but is this going to be something pertaining to ongoing pensions? I think it would be. As the pension committee, a place to go with something like this? These seems to me to be very big numbers here that could potentially happen.
Senator Begum?
Thank you, Mr. Chair. One, my understanding is that the retroactive would include 6 officers, law enforcement officers. And I'm going to ask counsel, Mr. Backus, to maybe talk about whether or not the pension issue would pertain to this at this moment in the discussion.
Mr. Backus?
Mr. Chair, members, I haven't really had a chance to refamiliarize myself with these sections, but as been stated, there's the death benefit, which would be $100,000. It could be more because there was a COLA provision in there that raises it. Then there's potentially an education benefit for the officers' children. And then I think there's also a continued health insurance coverage provision in there as well. But I don't think it has anything to do specifically with workers' compensation. I think that would be separate. These are benefits under 299A relating, that were specifically enacted in the 1990s or so for peace officers and firefighters and other people like that.
Thank you. Mr. Turner?
Yes, Mr. Chairman. I was going to point out what counsel said, but in addition, I guess there have been 6 suicides who would qualify under this.
That's my understanding, Mr. Chair.
Yeah, well then, do an off-the-cuff fiscal analysis. All 6 would be, their survivors would get $100,000, which would be determined. There's been COLAs in place since 1995. We don't know what that benefit is right now. And plus, as counsel pointed out, education benefits. And I seem to remember, it's been a long time since we've dealt with this statute, but as counsel pointed out, there's health insurance benefits as well. And that would be automatically triggered in with the retroactive clause. So you're looking at $600,000 with COLA and then education and possibly continued health benefits for the survivors.
Senator Limmer?
Mr. Turner, those estimates, where would they be drawn from?
Mr. Turner?
Mr. Chairman, Senator Limmer, it's not an estimate. It's, if there's 6 suicides, 299A.44 says payment required, their survivors get $100,000 adjusted to whatever today's dollars are. And so, I mean, that's, with the retroactive clause, triggering it would be 600,000 immediately, and then it's going forward. And then the uncalculable education benefits. So,
Ms. Turner, where would the money be
Senator Limmer.
drawn from?
Mr. Turner?
Mr. Chairman, Senator Limmer, we have created a peace officers benefit account. 299A.42 creates a public safety officers benefit account. Consists of money transferred. It would be money appropriated by the legislature. Money in account that is not expended in the fiscal years does not revert to the general fund. So DPS has an account. That account has a base amount. I don't know what the base is right off the top of my head, but that's general fund money that is appropriated every 2 years.
And for my clarification here too, Mr. Turner, you use the number 6 survivors. Where are you getting that information from?
Didn't,
Oh, Mr. Chair.
Senator Bingham.
It was either from the survivor of officers or law enforcement, conversation with law enforcement. I will note that I just received information from DPS that the benefit amount for a line of duty death was approximately $167,000 in 2021.
Further discussion, Senator Anderson.
Thank you, Mr. Chair. I'm just wondering, Mr. Turner, if that fund that you mentioned would be in lieu of workers' compensation?
Mr. Chairman, Senator Anderson, no.
No? Mr. Chair,
Senator Anderson.
in the letter from Ms. Katie Salifko, she mentioned that she was denied workers' compensation, but I'm just wondering if, because it says in the first paragraph that he had PTSD, and I'm guessing that he had gone to a health practitioner to get that diagnosis. So that's why we're adding PTSD into this language here, to consider that?
Yes.
So there is a documentation from a doctor saying that he did have PTSD.
Mr. Chair.
Senator Bingham.
Senator Anderson, yes.
Any follow-up, Senator Anderson?
No, thank you.
All right, thank you. Further discussion on the A42 Amendment?
Mr. Chairman?
Senator Limmer.
Senator Bingham, what would be the difference in cost if this was not retroactive but prospective?
Senator Bingham.
Mr. Chair, Senator Limmer, I'm sure we can provide that to you, but I would say that the honor and dignity and respect provided to the 6 that this would include is highly important for the departments, for their family. And again, I would just ask if maybe we can include this in your bill, and then as we move through the process, we can fine tune and talk with, have further conversation with maybe MPPOA and the survivor of Officer Salifko, and we can maybe have a discussion.
Mr.
Thank you,
Chairman?
Senator Bingham. Senator, do you want to follow up,
Chairman.
Senator Limmer?
Yeah. Senator Bingham, do you know if this is included in the other chambers bill?
Senator Bingham.
Mr. Chair, I can confirm that, but I believe it is part of their discussion, yes. I don't quite know what the other body, where they're at in their process of where their bill is, but yes, I believe it is in play and moving.
Okay, it's in discussion, but we don't know if it's,
Yeah, Mr. Chair, I just don't know where the other body's bill is in the process, is what I'm saying. Like where it stopped, is it in Ways and Means, or, I mean, that's what I'm saying.
Okay. Senator Ingebrigtsen?
Thank you, Mr. Chair. Senator Bingham, do you know if the military has such a benefit? Or maybe Senator Anderson knows that.
Anybody?
Mr. Chair,
Senator Bingham?
I do not know that off the top of my head, no.
Mr. Chair,
Senator Anderson?
not that I'm aware of.
Thank you.
Mr. Chair,
Senator Ingebrigtsen?
just my final comment on this. It seems like it's something that's absolutely needs to be looked into. However, it needs more work. I know Senator Howe's been working on this along with, I believe, Senator Duckworth and Senator Bingham. It's clear that you've been doing some work on this too, but there seems to be just way too many questions. And if it's going to be done, I think it has to be done right. So, members, I reluctantly would have to vote no, but I'm sure the legislature coming after us will be taking care of this thing, and they'll know exactly what they're voting on. So that's how I feel about it. Thanks.
Thank you. Senator Kiffmeyer?
Thank you, Mr. Chair. So, Mr. Chair, I know that Senator Howe, as stated, Senator Duckworth are working on this, having regular meetings and working with folks to get this hammered out in a better language. I think we should wait for that and respect what they're doing and the work that they put into it, that we can see this coming forward in the future. But at this time, I'd rather see us let those who've actually authored the bill and have been working on the language and meeting with the stakeholders to bring it forward.
Thank you,
Mr.
Senator Kiffmeyer. Senator Bingham?
I've actually authored the bill, and Senator Duckworth's aware of what I am doing.
Senator Limmer, final comment?
Mr. Chair, we have to move on. I agree with Senator Bingham that any police officer, public safety officer of any kind who has given up their life in defense of protecting our citizens certainly deserves our honor and respect. I have to admit, though, I'm leaning more in favor of the comments of Senator Ingebrigtsen, that if we're going to do this, we should do it with as much detail. I want to know if we're going to deplete the account going retroactive. We usually don't do retroactivity. I can understand the sensitivity of it, but I think for now I just have to reluctantly oppose the amendment. However, I'll keep an open mind as we progress to the finish line. But thank you, Senator Bingham, for bringing it forward.
That, members, any further comments? All right. Well, Senator Bingham renews the motion of the A42 amendment. All those in favor of the A42 amendment, say aye.
Aye.
All opposed?
No.
Amendment fails. On to the A35. Any further comments?
Mr. Chairman.
Senator Pappas.
Mr. Chairman, I have the A7 Amendment.
Senator Pappas introduced the A7 amendment. To the A7 amendment, Senator Pappas.
Thank you, Mr. Chairman. This is a very simple bill. We know the committee has supported the Office of Missing Indigenous and Murdered Indigenous Relatives before, and this creates a reward fund with a beginning amount of $110,000, and I'm doing this on behalf of Senator Kunish. And in light of the instructions from the chair, which I was not quite aware of, I would like to incorporate into my amendment that I have $110,000, and I would like to reduce $110,000 from line 77 on the spreadsheet. I'm not sure, someone else has to do the math. reduces it to 46-something million, 890. 890.
Spreadsheet.
The, just a little bit more on this bill, according
Sure.
to Senator Kunish, she also has gotten a lot of interest in donating to this type of fund, and she has a proposal in Senator Newman's bill for a specialty license plate, which would also raise money for this fund. And there is a limit on the reward offered of $2,500.
Senator Pappas, what, line 77, what is that fund?
Line 77 is the police retention bonus program that is currently at 47 million, so it would reduce that by 110,000.
Thank you, Senator Pappas. Further discussion on the bill, on the amendment?
Mr. Chair.
Senator Ingebretson.
Mr. Chair, and I understand the issue, and I know that there's been a lot of attention drawn towards the indigenous missing women and children. And it's something that we've been working on for quite some time. And I know Senator Pappas has worked on not only that, but also sex trafficking. And so I understand her passion and her concern. However, I don't think that offering a reward for a specific what am I trying to say? It should be all women, is what I'm trying to say, not just one particular group of women identified as indigenous or whatever. I just think that it's important that if we're going to set out rewards publicly, and I don't know if we've ever done this before, for information leading to, I think it's mostly done with private money. I think it should be, on a case-by-case basis, not anything that should be in law. So I would not go along with this amendment.
Further discussion on the A7 amendment? Senator Lance.
Mr. Chairman, to that point, one of the things that we learned when we established this office was that there is two things. One is there is a very high rate of missing women within this group, much higher in proportion to their population than I think in any other category of individuals. So it distinguishes this group from even black women or other ways that you might categorize victims or missing people. The second thing is that there is so the incidence rate is very high, but also there's an incredible backlog in investigations of these incidents, in part because they weren't taken quite as seriously as before, in part probably because the communities didn't always have confidence in reporting certain information. I'm thinking back to the hearings that we had on the initial bill to establish this office. Was just the incredible backlog over many years. We know that rewards are an effective way to draw out information, and it might be particularly helpful when you've got cold cases, or at least older cases, that people have sat on information for a long time that might be enticed to come forward. I think, from what I understand, the long-term plan is to raise funds separately for this reward fund, whether it's from the private sector or from other more local public sources, I'm not sure. But this would act essentially as seed money to jumpstart the initiative. And I think the amount that's involved here Because candidly, it's a pretty trivial amount of our budget, but it can be very significant for individuals that might have information that would be willing to come forward in return for receiving such a reward. So I think it's well worth the investment, and encourage members to support it.
Thank you, Senator Ladd. Senator Anderson.
Thank you, Mr. Chair. Mr. Backus, or can someone tell me if the state does rewards now to other groups of people in the state of Minnesota? The state collects money and passes out rewards.
Mr. Backus.
Mr. Chair and Senator Anderson, I'm not aware of something in statute requiring that, and that's funded by the state. That might be something individual agencies do, but I haven't really looked either.
Thank you.
Thank you.
Senator Anderson. Further discussion? Senator Latz.
Mr. Chairman, I would note that in subdivision 5 on the A7 amendment, it does authorize the office to accept grants and donations from public and private entities to implement the section. And it does have a cap on the amount of rewards. I think they just need some seed money so they can get the ball rolling here and get a jump start on these colder cases. Thank you.
And Mr. Chairman.
Senator Pappas.
Thank you, Mr. Chairman. I think if we haven't done it before, it'd be a good chance to try it, to see how it works. And as Senator Ingebrigtsen said, it could be then extended to other situations. But as Senator Ladd said, it really is just seed money, and they hope to get private donations as well as dollars from the license plate.
Senator Limmer.
Thank you, Mr. Chairman. I know that Senator Kunish has been discussing this subject with Senator Rosen. I tried to contact Senator Rosen prior to this meeting, thinking that this may come up. I have not gotten any comment back from Senator Rosen. I know that I am concerned about the reward advisory group being formed simply because we've already created an office for murdered and missing Indigenous relatives. I don't know why we would need to make a second organization that would consider the management of this reward fund that would be held in the state treasury. The dollar amount, where would you be taking that dollar amount from, Senator Pappas?
Mr. Chairman, from line 77, which is the
Line 77 of what?
of the spreadsheet.
Oh, our
Yeah, the police retention bonus program. It's one time. Mr. Chairman, the advisory group is, I think they could do that informally. It wouldn't have to be in law. But it's within the office. It's not a separate entity.
Mr. Backus. Do you have anything to add?
Mr. Chair and members, no, I was going to follow up on Senator Anderson's question earlier. I haven't had a chance to do like a definitive search, but I do see now that 299C.066, which is the BCA chapter, provides for a crime information reward fund created as an account in the state treasury, and then authorizes the commissioner, would be public safety, to pay a reward to any person who, in response to a reward offer, provides information leading to the arrest and conviction of a criminal offender. And the commissioner is authorized to establish criteria for the awarding of grant, and it's a maximum of $10,000. And I think there's also something in the Financial Crimes Advisory Board language. So there is some precedent, I guess, for these type of rewards.
Mr. Backus, would you repeat, where'd the funding come from? Was that out of their base appropriation?
Mr. Chair, let me go back to the one I started quoting from, which is the 299C.066. There's a fund, an account in the state treasury. And I believe the state would appropriate money for that fund, I believe.
Mr. Chair,
Senator Ingebrigtsen.
isn't that just opening an account, Mr. Backus, for people who donate to that fund, and they would be administered by the DPS?
Mr. Backus.
Mr. Chair and Senator Ingebrigtsen, I'm not exactly sure how that is, how that fund is filled up, so to speak. The statute, we're talking again, existing law, 299C, money appropriated to the account is available to pay rewards, so it seems like there is money appropriated to that account, but I don't know if that's, that's in statute. I don't know if that's currently being funded or not.
Mr. Turner, you got your mic on usually. That's a good sign.
Mr. Chairman, Senator Ingebrigtsen, I believe that there is a base appropriation for this fund, but that wouldn't keep it from accepting gift donations as well. But I do believe there's, it is wrapped up in the BCA base. I'm not aware, I don't know how much it is.
Senator Limmer.
Mr. Chairman, Ms. Turner, could I ask you to repeat that? Ms. Turner, could you repeat that? I didn't hear you. Is the DPS prevented from accepting monies to be deposited in this reward account?
Mr. Turner.
Mr. Chairman, it was my impression that they could accept money, but I was just told that that may not be the case.
Oh. Okay. Senator Pappas, do you know the progress of Senator Kunish's effort to get a license plate as a source of a donation for a reward fund?
Senator Pappas.
Thank you, Mr. Chairman, and Senator Limmer. Yes, I was next to her when she was told by Senator Dibble that it is in the Newman Transportation Bill, the license plate provision.
And so
Senator Limmer.
as funds accumulate there, the request you're asking from the police retention account to move to the same fund where the license plate monies would be deposited?
Senator Pappas.
Mr. Chairman, I'm not that familiar with the license plate bill. I don't know if it specifies that it all goes into the state treasury for the reward fund, or if there's other purposes allowed. Plus, to be honest, I don't know that license plates raise that much money. There's a potential of some there, but they have to pay for the plate. So it's not a huge source of funding.
Yeah.
Further discussion on the A7.
Mr. Chair,
Senator Limmer.
I like some aspects of this amendment, and I am not too revved up on others. I made mention of the reward advisory group. I do believe that a reward fund would be appropriate. However, I'm a little hesitant to remove it from the police retention fund. That may cause a danger to citizens if we don't keep police officers working.
Mr. Chairman, it's a huge amount,
Senator
though.
Pappas.
Thank you, Mr. Chairman. 47 million, I didn't think we'd notice 110,000 missing. And if the chairman would prefer, I'd be happy to accept an amendment or amend it to delete subdivision 3. Since I do believe that the office, if they wish to have an advisory group, they could set that up themselves. Yeah. So why don't we go ahead with that, Mr. Chairman? I'll just move to delete subdivision 3. What? Oh, that's right. I can just delete it. I'll incorporate that into my, to my amendment that I delete subdivision 3.
All right. So Senator Pappas deletes subdivision 3.
Okay. Mr. Chairman?
Senator Anderson.
Mr. Chair, later on in the subdivision 7, it mentions the reward advisory group, so we're going to have to delete that also, I'm guessing.
Could you state that?
Line
One more time.
2.22 mentions if Senator Pappas is going to remove subdivision 3, which is the reward advisory group, because it references it later on in subdivision 5, 2.17, and then in 2.22, it references the reward advisory group, I would think you would take those.
And 2.13. Thank you, Senator Anderson. We should delete.
2.13 is also has a
And 2.17 and
reference to that.
2.22.
And 1.16 as well. Thank you, Lynette.
Yep.
Okay, so subdivision 3 has been removed and the appropriate references within the bill in 1.16, 2.13, and 2.22 have also been removed.
Mr. Chairman?
Senator Pappas.
Mr. Chairman, Senator Limmer, if you're uncomfortable with taking $110,000 from line 77, is there another place that you would suggest that I could take that money, or there probably is just money on the bottom line?
Senator Limmer.
I don't know if there's any money on the bottom line, Senator Pappas. Like I say, Senator Kunish is working with Senator Rosen on this very same issue. The one concern I do have is where the money would be deposited. On lines 112, it says State Treasury, but we've heard comment that there's already an existing fund at the Department of Public Safety. Mr. Backus, is there a conflict with the existing fund for rewards at DPS versus, do they make the eligibility requirements and procedures for granting rewards? Because this language in 2.22 and 2.23 would counter that. Do you know if we're in conflict?
Mr. Backus.
Mr. Chair, members, I wouldn't say that there's a conflict. You know, if this became law, there would be 2 reward funds. This one would be specific to the missing and murdered indigenous relatives issue, and the other one is much broader.
Mr. Chairman?
Senator Pappas.
Mr. Backus, I think the question was, is that the proper language to say it's an account in the state treasury, or would it be an account with DPS?
Mr. Backus.
Mr. Chair and Senator Pappas, I think that this would be fine as it's in the A7.
Further discussion. Senator Latz.
Mr. Chairman, according to the spreadsheet, this bill spends $199,422,000. And if the target is $200 million, which the chairman is treating as a cap, that leaves almost $600,000 available within the bill to be spent under that target. So perhaps it's just a matter of increasing the spending in the bill by $110,000, and you're still within the chairman's target.
Mr. Chair.
Senator Limmer.
Mr. Chair, in my opening comments there, Latz, you may have missed my other comment, and that was we were waiting for a fiscal note on rape kits, and that was the difference in the bill dollar amount and the renewed spending limit that leadership gave me. Was hoping to use that difference for rape kits, and that's why Senator Bigham put an empty line on that possible appropriation. And so we're kind of in a holding pattern until we get a fiscal note on that. It may blow the bank on that as it is. So I just wanted to let you know that. The one question I did have, and I understand the comparison between the 110,000 versus the budget bottom line. Senator Pappas, your bill still directs the money to go to the state treasury, but we have a reward account at DPS that does it hold funds? Well, maybe Mr. Backus could answer that. I'm unfair to ask you that. Senator Backus?
Mr. Backus.
I'm sorry, Mr. Chair, what was the question?
Senator Limmer.
Mr. Backus, you've informed us that there's a reward fund established at the Department of Public Safety for reward accounts. And the question I have is could these monies that might be collected, could it be deposited under a separate designation and held by the Department of Public Safety?
Mr. Backus.
Mr. Chair, members, I don't know if I fully understand the question. The 299C reward fund that I've been referring to also talks about, it is also created as an account in the state treasury. It's fairly similar to this in terms of how it's structured. Are you asking, you know, if as a policy choice, if you wanted to combine the two or something, are you asking that?
Well, I'm trying to
Senator
understand, Mr. Chair, I'm trying to understand the mechanics of the account.
Mr. Chairman, I think that's just
Senator
the
Pappas.
common way of stating it, that it's in the state treasury.
Yeah.
Mr. Backus did say that a few seconds ago. Maybe you didn't hear him a few minutes ago. You don't have to specify Department of Public Safety.
Yeah.
And
It's just a separate line item. They don't actually do a whole account.
Senator Limmer.
In the case of the Department of Public Safety managing the account, do they make the actual decision to reward the dollar amount in the existing fund?
Mr. Chair and Senator Limmer, yeah, in the 299C.066 provision, the Commissioner of Public Safety is authorized to pay the reward to any person who the Commissioner determines merits the reward. And this, the A7, it's the Director of the Office for Missing and Murdered Indigenous Relatives who would do that, initially in consultation with the advisory group, but now that would be deleted.
Mr. Chair,
Senator Limmer.
I see that that answer is a little different regarding who is authorized to issue a reward. If you see in lines 15 through 18, we're allowing the Director of the Office for Missing and Murdered Indigenous Relatives in consultation to a reward advisory group, which is no longer there, would mean that it's authorized to pay a reward to any person who provides relevant information. Usually rewards go to people that the information leads to the arrest or conviction of someone who is found guilty of participating in the disappearance or the murder of someone, someone that would be instrumental in that effect. This seems awfully broad to just provide relevant information. I'm a little concerned about that, the lack of specificity, and it may not result in any eventual outcome.
Mr. Chairman,
To this point?
to this point?
Yes. Senator Latz.
Mr. Chairman, I'll note the difference between this reward fund and the one in the BCA. Number one, this one is capped at $2,500. The BCA one is capped at $10,000. Second point is that these are largely cold cases. And so right now, I think they're just looking for anything to go on to get the investigations rolling. So if you just say it's got to be good enough information to lead to the arrest and conviction, that might be just too tenuous a connection to be effective on cold cases.
Mr. Chairman.
To this point?
Yeah, to this point, also, there is a provision in the bill in subdivision 7, 221 to 223, that the director would determine eligibility criteria. So they could certainly narrow it from relevant information to, leading to a conviction or leading to a resolution of the case. but because we wanted to give them some flexibility in terms of what that might be.
Okay.
Thank you, Mr. Chairman. Well, that widens my concern because of a lack of eligibility criteria. From our perspective, it seems like it's awfully broad. Is there a way to tighten that up or help in that criteria?
Senator Ingebrigtsen.
I'm sorry, I didn't take my hand down, I'm sorry.
Thank you.
I think we do whatever we can.
Any further discussion on the A7 amendment?
Yeah, or a resolution of the case or something, because it could be dead, people could be dead too.
Any further discussion?
Mr. Chairman, Senator Latz and I were just consulting about tightening it up as Senator Limmer suggested. We could put that under 1.17, relevant information, or we could put it under determine the eligibility criteria. Maybe Mr. Bacchus could help me, but I thought provides relevant information leading to an arrest or resolution of the case. Because arrest may not be, or conviction would be another word, may not be relevant, people could be dead, so then you can't do an arrest or a conviction. So perhaps relevant information leading to a resolution of the case. Or we could say conviction or resolution of the case, whatever the committee thinks.
Mr. Bacchus, do you have any suggestion regarding that language?
Mr. Backus.
Mr. Chair, members, it depends on what you want to put in. The language that Senator Pappas at least initially said seemed to make sense. On line 1.7, after information, insert leading to an arrest or resolution of a case. If you want to require it leading to a conviction, you could do that. It's really up to the committee.
It seems to me conviction might be
Senator
better,
Pappas.
Mr. Chairman, might be better than arrest.
Senator Pappas, your recommendation is conviction?
What do you think, Senator Limmer?
I think I would accept that language, Senator
Okay.
Pappas. Or
Conviction?
I would recommend that language.
Right.
We're not done with the amendment.
So we're doing a lot of work on this bill that we could have done earlier. I regret it's on our last day here. But
We
so
did a
now
lot
I'm
of work
incorporating.
already, Senator Pappas.
I'm sorry, what?
We did a lot of work already, Senator Pappas, as well.
Yes, absolutely. So I'm now incorporating in line 1.17, after information leading to conviction or resolution of a case.
Okay. Committee members,
The,
get that?
sorry, I have another potential change based on Senator Limmer's concerns, is we could also, as we did with Senator Bingham's bill, we could leave 1.6 blank and not take anything from line 77.
Further discussion?
Why don't I just go ahead and do that? So, Mr. Chairman, if you'd like me to
Senator
go over
Pappas.
the changes.
Yes, please.
Okay, so on line 1.6, blank is to implement a new Minnesota statutes. On 1.16, delete in consultation with the Reward Advisory Group. On 1.17, after information, insert leading to conviction or resolution of a case. Delete subdivision 3. On 2.13, delete in consultation with the Reward Advisory Group. On 2.17, delete in consultation with the Reward Advisory Group. And on 2.22, delete in consultation with the Reward Advisory Group. I've incorporated all of that into my amendments, so I appreciate your support, members.
All right.
Mr.
Senator
Chairman,
Limmer,
I'm going
final
to leave it
thought?
up to, I'm going to leave it up to the committee to decide.
Okay.
Then, Mr. Chairman, I'd
Further
move the new
discussion, Senator Powell.
A7 amendment with all of the incorporated changes.
All right. Senator Pappas moves the A7 amendment with the incorporated changes. All those in favor of the A7 amendment indicate by saying aye.
Aye.
All opposed? No.
No.
Boy,
I can ask for a division. Make it easier.
division's been requested. Okay. All those in favor, please raise your hand. I've got 4. All those opposed? 5. Seeing, Ingebrigt's, okay. Motion does fail. All right, back to the A35 amendment. Any further discussion? Me up there. Oh. So Sarah Ingebrigtsen, could you mute?
A35.
Okay, thank you. All right, to the
Mr.
A35
Chairman?
amendment,
Mr. Chairman?
Senator Limmer.
I'm a bit confused when you make mention of the A35 amendment. That was the first amendment that we passed. I'm just confused by that reference. Could you
Whichever,
specify?
I'm sorry,
Maybe I'm the only one, but
the DE amendment. We adopted the A35 earlier. I'm sorry. So the DE amendment.
okay.
Further discussion? Senator Latz.
Yeah, Mr. Chairman, I think that the A35 was incorporated into the A5.
That's correct.
DE.
That's correct.
So then to the A5, I'd like to offer the A31 amendment.
Senator Latz offers the A31 amendment. To your amendment, Senator Latz.
Thank you. Mr. Chairman, and Senator Limmer, you may recall, we did have a conversation in committee about attorney access to court records and also to courthouses, which was part of my bill that I had offered. The courthouse component of that, I think, has met some logistical barriers since courthouses are secured by county sheriffs. And I think trying to make something like that work at a state level right now anyway would be a little unwieldy to try to mandate, some kind of a process to allow the licensed attorneys to access the courthouses. So I've dropped that provision, but the A31 amendment does address the portion that dealt with attorney access to court records. Just a quick refresher, under the current public access, any member of the public can access Minnesota Court Information System case records through the MCRO portal, but the records available through that portal are not all of the records in a case. Some records are not accessible, and rightfully so, because some records are contain information that should really only be a part of the case. I will, or at least in terms of online accessibility, more records are available at the courthouse than available online. Right now, however, prosecutors and public defenders, as employees of government entities, do have access to all of the case records in all of the cases in Minnesota through the MGA, or Minnesota Government Access Account. Licensed attorneys would, in the private sector, would find it enormously convenient and efficient to be able to have the same access to case records online that public defenders and prosecutors have, including prosecutors in their own cases, who have greater access to the online court records than the private attorneys have. So this amendment would accomplish that. And it would allow then the licensed attorneys, admitted and licensed to practice in this state, to apply for the Minnesota government access account. So that's my request, Mr. Chairman.
Thank you, Senator Latz. Discussion by the committee. Senator Kiffmeyer.
Thank you, Mr. Chair. This has the look of something that when you're talking about access on court records, that the judicial system controls that, and they may have to do work that would cost money to create this kind of a system. So I see both money and then also reaching into the judicial branch on access and other things. So while this looks like it may be, I don't know, maybe it is or isn't, I certainly know that attorneys would be glad to have that sort of free access. But it has court authority and then it has cost as well. And so I'm wondering, has the judicial branch, I think they have an entity that looks at things like this and makes some decisions or recommendations. But on its face, to me, this looks like two issues for this, not dealing with whether that's of merit or not, but anybody would like free access to these kinds of things for your work, but at what cost, either to us or judicial, and then the authority question.
Senator Latz, would you like to respond to that?
Mr. Chairman and Senator Kiffmeyer, there was a fiscal note that accompanied this bill relating to this particular provision, feedback from the courts on it. As I recall, they did not raise any issues with regard to authority. I'm working off of memory here. I don't have it in front of me, but I don't think that was their concern. They did note some concern about changing their computer system to be able to process applications by private attorneys to give them, the attorneys of government, the same access. Currently, they're able to do it through government entities because public defenders are employed by the state. Prosecutors are employed by counties or on contract with municipalities. And private attorneys are not employed by government agencies. And as I recall, I guess it would depend on how many lawyers were to apply for it, for this level of access. I also suspect the courts could charge a processing fee that would recoup the cost of their implementing a system, either on a one-time application basis or on an annual basis. I, for one, would be happy to pay a little bit to be able to access these records without having to leave my office for a whole variety of cases. So I don't know that we would need to specify that. I think the courts probably have the authority to do that without us specifically authorizing it in a statute. But I would anticipate that would be the way that they would handle it, to the extent there would be a cost.
Senator Kiffmeyer.
Yeah, thank you, Mr. Chair. The other thing this committee has gone before, in this language here, it says an attorney shall be able, we're basically telling the court what to do with their own system, shall be able to view and print without cost to the attorney. Now, even if there's a fee with cost to the attorney, it's still here in the legislature reaching over to another branch of government saying they shall be able to do this, and these are case documents and court information, court records and so on. It's in the Minnesota Court Information System, and policy of this committee has been to have concern about telling the court what they shall do. Now, the court on its own, as I understand it, could do something like this on its own and charge a fee. So I don't know that we need to legislatively say, you're going to do this with or without a cost. I think those are concerns I have.
Thank you, Senator Giffmeyer. Any further discussion on the A31 Amendment? Mr. Turner?
Yeah. Mr. Chairman, members, I just called up the fiscal note. The court doesn't say that this would absolutely be necessary, but if the system needed overhaul because of the thousands of new users, they said based on similar projects, the cost of developing and implementing a new system is estimated to be approximately $1,587,000 with annual ongoing support costs of $445,000 per year. Now, that isn't listed in the front of the fiscal note as a definite cost. It would only be if the system was overwhelmed, and that would be the cost of putting in a new system to handle the new traffic.
Further discussion?
Mr. Chairman.
Senator Latz.
Mr. Turner, did the fiscal note make any reference if the access were limited to the attorney of record on the case? I suppose you'd still have all lawyers needing to go through to get the permission to access it. I mean, if there's a way to narrow the access, I mean, I'm fine, with attorneys accessing just the records in a case where they're attorney of record, if that would avoid some fiscal costs. I don't know if that would under the court's analysis or not.
Mr. Turner.
Mr. Chairman, Senator Latz, I'll read you exactly what the court said here. It is assumed that if up to 25,000 additional users were added to the MJ system, that system may experience performance issues, as it was not designed for this type or level of use. It's assumed that if the performance issues were significant, the judicial branch would explore designing and implementing a separate system for private attorneys and would approach the legislature at that time for additional funds. And then the funds that I stated, $1,587,000 for implementation and with ongoing support costs of $445,000. And then, as we've been talking, the Supreme Court has texted me that they cannot charge or recoup money without legislative authority. So that would have to, we would have to give them the authority to charge a fee of the attorneys.
Senator Latz.
So, Mr. Chairman, it sounds like they're punting to us with regard to giving them authority to charge, to recoup costs. So it's kind of a hazy line as to where each institution wants authority to rest, kind of depending on what they want to accomplish, I suppose. Right? Mr. Chairman, I would love to see this happen, but it sounds like we're going to run into some issues with regard to the courts and funding on this. I'd hope that we can take a better look at it some other time, but I'm going to withdraw the A31 Amendment.
Senator Latz withdraws the A31 Amendment.
Mr. Chair.
Further discussion on the A5. Senator Begum.
Mr. Chair, I'm going to offer the A24 Amendment.
Senator Begum offers the A24 Amendment.
Thank you, Mr. Chair.
Senator Begum, to your bill.
Thank you. I did speak to, along with the stakeholders, spoke to Senator Limmer, rookie mistake, on this amendment. The A24 Amendment seeks to close a small gap in our state's controlled substance statute by including a federally recognized Indian tribe in the list of governments that can designate an area park zone. As you know, that a number actually of our criminal drug statutes change criminal charges if they are designated in a park zone. And so it just provides parity and that there's no fiscal impact to it. And I did confirm with the County Attorneys Association that they review and support it. And so I would ask the committee's support.
Further discussion on the A24.
Mr. Chairman.
Senator Limmer?
Mr. Chairman, Senator Bingham, have you talked to any Indian bands regarding their reaction to this designation?
Senator Bingham?
Mr. Chair, Senator Limmer, yes, Laura Sue. They support it.
Senator Limmer?
Mr. Chair, I know there's 11 federally recognized tribes in
Yes.
Minnesota. Have you talked to all of them?
Senator Bingham?
Mr. Chair, no, but this would have a statewide impact.
I know it would.
Senator Limmer?
We're creating a designation in a sovereign Indian reservation. I'm just a little, I'd like to know what they think about it before we would actually make that designation for them. I think they get a little sensitive to that.
Senator Bingham?
Mr. Chair, Senator Limmer was one of the federally recognized tribes that brought it to me just a couple days ago. I don't know if all 11 support it, but it was brought to me by them. And this is about parity. It's pretty clear cut because in our codes, there are enhanceable crimes in our controlled substance area if it's done in a park. So manufacturing, using, possession, all are enhanceable, and all they have parks on tribal land, and they want that parity. And Mr. Chair, one other thing.
Senator Bingham?
I just received word that they have, Lower Sioux has spoke to the other tribes. They just don't have anything formal yet, and so.
Thank you, Senator Bingham. Mr. Backus, would you be able to just quickly kind of walk through this as well? So what, I'm still struggling on just exactly what this does then for the Indian tribes in the reservation area.
Mr. Chair, members, if you look at the line 1.5, beginning on line 1.5, so park zone means an area designated as a public park by, and then there's a list of entities, the federal government, the state, a local unit government, et cetera. So this would include a park designated by a federally recognized tribe. So the impact of this, as Senator Bingham mentioned, is in the controlled substance laws, we have a number of instances where the threshold amount changes based on whether the crime is committed in a park zone or a school zone. That's also true in the prostitution crimes and the dangerous weapon crimes. So it would have that effect of changing penalties for crimes committed in a park zone to include parks that are designated by federally recognized tribes.
Thank you. Any further comment?
Mr. Chair,
Senator Limmer?
the one thing I try to do when I'm dealing with our relationship with Indian bands is recognize their sovereignty. I really think they get sensitive to the fact that we sometimes make decisions on their behalf without asking them. The other thing that came to mind is that of what Mr. Backus just said, that there may be different designations for penalties. I know that there's some legislation being considered by the other body in the Health and Human Service Department, or not department, committee, regarding a potentiality of the use and sale of marijuana. And I don't know how this would dovetail in it or not, but because of those unknown relationships, I would oppose the amendment for now. If we have a little more designation from the other tribes, I'd feel more comfortable.
Mr. Chair,
Thank you. Senator Bingham.
I'll withdraw the A4 amendment. Is
Senator
that- wait,
Bingham
was that the
withdraws the
right one? A24.
24 Amendment.
Thanks.
Further discussion?
Mr. Chairman.
Senator Pappas.
Yeah, I have the A38 amendment, and I have some handouts if the page could pass them out.
Give them a moment.
A38.
All right. Senator Pappas.
Thank you, Mr.
To the
Chairman.
A38 Amendment.
Yeah, the A38 Amendment directs the Police Officer Standards and Training Board to establish rules for physical strength and agility examinations required by law enforcement agencies, and that those rules should be scientifically content validated and job related. According to MPPOA, it's an important step to make sure that any physical strength and agility requirements are job related to law enforcement and unified across the state for the profession. They were developed by the League of Minnesota Cities in consultation with the groups that they worked with are, sorry, just misplaced. It's in accordance with the Equal Employment Opportunities Commission Uniform Guidelines on Employee Selection Procedures, et cetera. At any rate, you see I have support letters from the League of Minnesota Cities and also from the Minnesota Police and Peace Officers Association. I think it's to make sure, just to summarize, that the strength and agility tests that are required are scientifically content validated and job related. I appreciate your support.
Thank you, Senator Pappas. Discussion on the A38 Amendment.
Mr. Chairman,
Senator Limmer.
I'm going to call a friend, Senator Ingebrigtsen, and see if he has any comment regarding this, having had a past in the law enforcement career. What does he think of this?
Well,
Senator
thank you, Mr. Chair. Mr. Chair, and I had my hand raised already. Every department has their own, physical agility policies and how to stay in shape policies. I would have to say probably they're much more stringent than they were in the past. And because of the nature of the business seems to be getting to be more where you have to be more fragile, more strength training and the ability to move quick. So to make it a statewide standard, I think is and I'm not quite sure where the MPPOA is coming from, but it's going to really limit these smaller towns' abilities to hire somebody if they happen not to make the the physical account with a statewide thing. And that statewide thing kind of bothers me a little bit. Although I do want officers to be in shape. Everybody wants that. But to make it a statewide standard, I'm not sure what that effect would have on these smaller departments. So I'm just not very comfortable with it without looking into it a little deeper.
Mr. Chairman.
Thank you, Senator Ingebrigtsen. Senator Pappas.
Mr. Chairman, just to comment on that, I'm sure that the League of Minnesota Cities and the MPPO and the Post Board all took that into consideration, but they really think it's important to have a consistent standard for the physical strength and agility exams that are required. And then when if police officers move from one department to another, the hiring agency can be assured that they've met these consistent standards. So I would urge the committee to support them. I think when outside groups do all the work to bring these issues before us, we should respect the work that they've done and pass the legislation into law.
Mr. Chair?
Senator Ingebrigtsen.
Mr. Chair, and Senator Pappas, I think I understand where the League of Minnesota Cities is coming from. It's coming from basically, obviously, a liability situation where officers are either not keeping themselves in condition or so they become a liability. And I get that. I understand that. And to make a statewide standard like that, I guess I would love to see something like that if you had the officers that you could do that with. But right now, I'm afraid that we're going to be doing some limiting and some opportunities that may not be able to fill positions because of maybe somebody can, pick up 45 pounds, but they can't quite pick up 50. Is that going to make them a liability? I guess, it's everybody's call on this. I just think it needs more work, but I do agree with the concept. I'd love to see everybody in condition in their ranks and roles as law enforcement officer. In fact, they should be doing that themselves. So I just think it needs a little work, but I understand the League of Minnesota Cities.
Senator Pappas.
Yeah, Mr. Chairman, since Senator Ingebrigtsen isn't with us to see my handout, I just wanted to share some things from the League of Cities. You're partially right, Senator Ingebrigtsen. And these are just administered to applicants, not ongoing police officers. And it says the League has been working with various public safety stakeholders on a content-validated physical abilities test that's job-related and reasonably priced to be given to job candidates after an employment offer has been made. They're motivated by a desire to ensure our city has access to a test that accurately reflects the physical abilities required on the job for peace officers, and a test that was legally defensible and logistically workable, and to ensure that the test did not discriminate against female job candidates who are able to perform the physical requirements of the job. And then they state that they're in support of this legislation. So I would hope that the members would seriously consider this and vote for it.
Thank you. Senator Kiffmeyer.
Thank you, Mr. Chair. And I think it is something, as Senator Ingebrigtsen said, of wanting to be sure they are. However, I would also make a point that the date, December 1st, 2022, by the time we pass legislation, goes into effect, and everybody needs to be ready to be prepared for that. I think it's a way too ambitious. And right now, when we already have a shortage, we're adding on some other areas, worthy as they may be. Nonetheless, the last thing we need right now is to make it even more difficult to fill those jobs that are very, very important to public safety. If we were going to do something like this, I think it's very important that this is much too ambitious of a date. And applicants, when you say applicants, well, you apply when you're even moving from one police department to another. So some of these things and meetings, you need to get these standards out there. The applicants need to know what they are so they can prepare for the test. And that doesn't allow for anything here. It just says December 1, this is what they got to do. And scientifically, content valid, that's going to take time too, and make sure they're job related. This takes time to put this in place. And if I recall, we had another time when we were trying to do something and make requirements, and the time frame by which you're doing it didn't allow enough for all the work that needed to be done to prepare for this. So even if we did this, I appreciate others' comments on this, but this is way too ambitious a time frame for the practical implementation of the post board, but more importantly, of all of the applicants who might be moving from one area to another.
Thank you. Senator Lance.
Mr. Chairman, it seems to me that the time to make sure that there are not discriminatory standards in place is when you have a lot of hiring to do. We have a lot of positions to fill, sure, but we don't want police departments to be filling them in a discriminatory manner that biases their screening process in favor of men and against women. And once these positions are filled, presumably, especially if there are hiring bonuses and retention bonuses and so on, these positions are going to remain filled, hopefully, for a good long time in the career of the law enforcement officer, thereby blocking any folks who are discriminated against from having another opportunity to get into the field. I strongly suspect that there are off-the-shelf examinations available right now that would meet legal standards and would be financially responsible, that cities could adopt, or even the post board, frankly, could review a few and say, these are acceptable, and according to what we understand to be legally required and non-discriminatory in application, and go ahead and just, when you do your screening, use one of these 4, 5, 6 different tools or vendors to implement it. So I don't think this is something that's going to require years and years of development of scientific tests and going through double-blind, weight lifting examinations to see what affects women more than affects men. I think this is being made to be a lot more complicated than it really is. And I'd hate to leave in place any examinations that are, as a matter of practice, going to have the effect of discriminatorily freezing out women applicants as a practical matter from positions that won't be open again for the next 10 or 15 years. So the time to do it is now, when there are openings to fill.
Senator Kiffmeyer.
Yeah, thank you, Mr. Chair. I'm a little bit puzzled by the use of the word discrimination in the context of this language that's in front of me. I've read it now 2-3 times. I do not see this discrimination, but I'm just talking about if you're going to do it, make it fair to people to be able to be prepared and for the agencies to do implementation. And I thought it was another curious thing. You're going to have physical strength and agility screening, but it doesn't apply to tests of an applicant's cardiovascular health. Last I know, your cardiovascular health has a lot to do with your physical strength, and I think it's kind of interesting here. So we want to be sure that men don't use their physical agility to make sure that women aren't shut out, if I recall right, in discrimination aren't shut out. So biological men might have some physical strength capabilities that maybe women do not have, and then that would disadvantage women. I think that's what you're saying here. I find that kind of interesting. But then you say it can't apply to a test of their cardiovascular health or general physical fitness to serve as a peace officer. I'm becoming more and more wondering what this amendment is actually about. Thank you, Mr. Chair. The timing and implementation is one thing, and then it seems to be conflicting within itself by saying you can't apply tests of cardiovascular health or general physical fitness, but you're going to test their physical strength and agility. That seemed very puzzling.
Thank you, Senator Kiffmeyer. One question I do have too, there is a dollar amount on this bill. Senator Pappas, where do you recommend that comes from on the spreadsheet?
Mr. Chairman, since there really is no legal target in committee, I'm just offering the proposal.
Mr. Chair,
Senator Ingebretson.
just a couple more comments if I could. Quite frankly, this is going to ultimately make recruitment of officers even smaller, and that's a problem, right? Especially right now. And with regards to discriminatory, it seems to be a word that we use when we don't sometimes have any basis of such. I guess I would ask Senator Latz a question after this next comment, but I do know for sure that the skills course or the training of police officers have to go through in Minnesota already, that they have to not only do mental testing, but they also have to do physical agility testing. And that's men and women alike. And I don't know of any institutions in the state of Minnesota and or the community colleges, the 8 or 9 community colleges that are actually putting out police officer candidates that discriminate against men, women, and or color. So if Senator Latz has any data that he can come up with that's saying that anybody's discriminating against hiring of police officers, whether it be of color or of gender, I'd like to know where that is.
Senator Latz?
Mr. Chairman, I don't have any data to answer Senator Ingebrigtsen's question. These issues have been around for years. Anyone who pays attention to the employment field and job applicants for all sorts of fields. Firefighters were a favorite issue where they had just unconscionably difficult strength requirements that weren't really tied to the job requirements, but had the effect of keeping almost every woman applicant out of the firefighting field. In any case, all I know is the MPPOA supports this, so they must think it makes some sense, Mr. Chairman. I ask for a green vote on it.
Any further discussion?
Mr. Chair.
Senator Limmer?
Mr. Chair, this seems like an issue that I'm surprised that this issue hasn't come up in recent years, like in the last decade. I know that there are physical agility tests. Even way back in my early life, I applied for police officer jobs, and even back then, 40 years ago, had physical agility tests that I had to pass once you got up to a certain level of consideration as the field narrowed for an applicant. I'm not going to say that I failed the agility test, but nevertheless, it was quite vigorous. I think this is an issue that we could revisit next year, and I think it would be an appropriate one during that time, but I would prefer keeping it out of the bill this year.
With that, this was Senator Pappas. Senator Pappas renews the A38 Amendment. All those in favor of the A38 indicate by saying aye. Aye. All opposed?
No.
Motion fails. Members, at this time, we will pause for a 20-minute break, and then we'll resume other amendments and comments after that point. So we'll be back here at 12:50. Thank you. Any further comments or amendments by committee? Senator Latz.
Mr. Chairman, I have the A49 amendment, please.
Senator Latz has the A49 Amendment. Members, do you have that in your packet? Oh, it needs to be passed out here to members. If we could do that.
Shall I start describing it while it's being passed out, Mr. Chairman?
Certainly.
Members, the A49 Amendment addresses conditions of release from custody for DWI arrestees who are either high first tests, meaning .16 or higher, or repeat offenders. The statute currently requires that they be held for court, and a judge can only release them either with the maximum bail of $12,000 or a conditional release that includes alcohol monitoring to assure their abstinence or sobriety while they are awaiting their court appearance. Right now, in many counties, that conditional release, in other words, the alcohol monitoring condition.
Kurt, just put Amendment 46, A46 Amendment, just for those following along at home.
I have A49 in front of me.
There it is. And it's exactly what you're describing, Senator Lett. Do you want mine? Here.
It is not exactly what I'm describing. It's the A49. A49 is my most recent version of this amendment.
Mr. Chair, members.
Last, we could just pause from, Senator, or I'm sorry, Mr. Backus.
With some of these amendments, there are multiple versions of it. This amendment I just emailed out to the committee group. I don't believe there are copies made, but you all have a copy in your inbox right now.
Mr. Backus, I don't see one quite yet. Hold on. There it is, just popped up. Members have it?
No.
Okay. Sage will be printing one for you, Senator Limmer.
Oh, okay. Okay. Mr. Chairman, it should be in everyone's
Senator
electronic inbox, but if people would prefer physical copies, we can get this copied and I can use it, go to a different amendment that I think might be in your packets.
Yeah, why don't we do that then, Senator Latz? Why don't-
Okay, I'll withdraw the A49
Okay,
and
thank
ask to
you.
have it copied.
Thank you, Senator Latz. Senator Latz,
Thank you. Then, Mr. Chairman, I offer the A36 amendment, please.
Senator Latz offers the A36 Amendment to the amendment.
Mr. Chairman, the A36 amendment addresses the safety of our healthcare professionals and all people in our healthcare services that are taking care of people in their facilities. Right now, it is a fourth-degree assault, a higher-level assault for persons who assault firefighters, emergency medical personnel, and healthcare professionals in a hospital emergency department. It is a particularly risky job. But there are other people in the hospital that are dealing with very difficult patients outside of the emergency room, up on the other care floors, and family members of some of those patients. So this bill basically removes the hospital emergency department language. You can see this on page 2 of the amendment, and expands coverage to all the persons providing healthcare services. It also provides expanded language to the fourth-degree assault statute, which mirrors language that is found in other fourth-degree assault provisions relating to peace officers. So it would then make it a fourth-degree assault, which is a felony level assault, not only for inflicting demonstrable bodily harm, but also intentionally throwing or transferring bodily fluids or feces at or onto these covered persons. That's the operative criminal penalty provision in the bill. If you go back to page 1 of the bill, it also establishes a healthcare professional well-being, education, and outreach initiative, recognizing that our healthcare professionals, especially in the last couple of years, have been under extreme stress. They've literally been on the front lines of the pandemic and are having a lot of burnout. And the retirement rate for nurses and other healthcare professionals has been very high. And they, probably more than almost any other people in our community, literally taking care of the COVID patients in the hospitals and facing down the infectiousness and in some cases the death sentence that having a COVID infection can cause. We believe they need extra support for their own wellness, and it would benefit all of us if they can remain in the profession as a result. We already have a nursing shortage in Minnesota, which I don't, memory serves, it's in the range of 30,000 nurses or something like that. So we need to hang on to every one of our healthcare professionals that we can. So there's an initiative to address those concerns, as well as an appropriation to do so. I believe the appropriation is a tails-only appropriation, if I'm correct. It's zero in this fiscal year and then $1 million in the next fiscal year. Mr. Turner.
Mr. Turner.
Mr. Chairman, members, the zero refers to fiscal year '22, so it'd be $1 million in fiscal year '23. And then as it is right now, this would be ongoing, but.
Okay. So, Mr. Chairman, that's the amendment I'd ask the members to support.
All right, thank you, Senator Latz. Members, any discussion? Senator Kiffmeyer.
Mr. Chair, in reading this in front of us right now, I see that this is direction to the Commissioner of Health. And then there's also a work group comprised of healthcare professionals. Work groups go to State Gov, and the Commissioner of Health is that area belongs over in HHS. So we have HHS with the Commissioner of Health, work group, and laying that out is language that should come before the State Gov Committee. That's our jurisdiction. So I see some of these worthy things going on here, but I don't think we have jurisdiction here. And plus this work group has not been reviewed by the State Gov Division.
Thank you, Senator Kiffmeyer. Further discussion? To that point?
I would just ask, maybe staff can look up what path the original bill that was introduced by Senator Klein was given for referral. Clearly, the criminal penalty provision is properly before us here today.
Senator Anderson.
Mr. Chair, line 1.4, asking for $1 million, is that, where's that money coming from?
You're wondering about the funding, Mr. Turner?
I'm sorry, Mr. Chairman, I was doing something else. Could you
Sure.
repeat your question,
The
Senator?
question was simply, where's the funding coming from for that $1 million of ongoing spending? 1.4.
Mr. Chairman, wherever Senator Latz would like it to come
Senator Latz, would you like to address that?
Mr. Chairman, it would come from the general fund.
Senator Anderson, follow up?
Well, Mr. Chair, I think as Senator Kiffmeyer said, this is, belongs to healthcare, should maybe come out of the healthcare committee rather than out of our committee.
Mr. Chairman?
Senator Latz.
I am informed by staff that the bill was originally referred to Judiciary as its first stop. It was not given a hearing, so, excuse me, it was not given a hearing, so it was not given the opportunity to be re-referred to any other relevant committees.
Thank you, Senator Latz. Any further discussion?
Mr. Chairman.
Senator Limmer.
Mr. Chairman, due to the fact that the dollar amount exceeds our spending limit and there's questions about our jurisdiction, I would be opposed to the amendment.
Thank you, Senator Limmer.
Mr. Chairman,
Senator Latz.
I will change my amendment to delete sections, line 1.3 to 1.28, so there would be no jurisdictional issues relating to this, and that would simply leave, there would be no dollar amount associated with it. It would just have the change in section 22, which is on page 2 of the bill, relating to the criminal penalty and coverage for the crime. So there'll be no fiscal impact.
Mr. Chair?
Yes,
Senator Kiffmeyer.
taking out section 9 and section 19 of the bill.
Senator Kiffmeyer.
Well, Mr. Chair, when you leave a large number of people, as you do in section 22, let's deal with line 2.2, even if it's amended, to think that there's no fiscal note, guilty of a felony and sentenced to imprisonment. From what I recall from just being in this committee, though, if you add this additional group of people to this, worthy as these folks are of what they're going through, that's still going to have a fiscal note. We've done fiscal notes for less than this.
Mr. Turner.
Mr. Chairman, members, yes, this expansion of 4.3, it is 4.3 assault, I believe. There's no fiscal note that was requested, but it would definitely be a candidate for a fiscal note.
Thank you, Mr. Turner. Further comments, questions? Senator Latz.
I just looked this up online here, and it does show a fiscal note on March 2nd of 2022. So maybe it hadn't made it into Mr. Turner's notes yet. In the
Well, Mr. Chair,
Corrections Department fiscal note looks like it would be $10,000, if I'm reading this correctly, in fiscal year
That
'23.
makes sense. Maybe for the work group.
This is what's online.
Mr. Chair, 10,000 sounds more like the cost for this, some other work in the bill, but I cannot imagine that $10,000 would be the only cost by adding a large number of other healthcare professionals. That is a huge, many hundreds of thousands of people that would now be brought into this. And I don't see how you get away from a fiscal note here on this kind of penalty applied situation.
Thank you, Senator Kiffmeyer.
Point one, so
Further comments?
corrections would be
Corrections would be 10,000.
10,000.
Yeah, with the tails as it continues.
Okay. So,
Okay.
Mr. Chairman,
Senator Latz.
consulting with Mr. Turner here, the fiscal note for the Corrections Department bed impact would be $10,000 in fiscal year '23, with tails of $25,000 in '24 and $32,000 in 2025. So, Mr. Chairman, that $10,000 would amount to something like 0.0111% of the $9 billion surplus that we have, Mr. Chairman. It could probably be absorbed by the staff cost of running today's committee hearing. So, Mr. Chairman, I'd ask for the committee's support in favor of protecting our healthcare workers from assault in their hospital or healthcare settings.
Mr. Chair?
Senator Kiffmeyer.
Okay, in regards to this, Mr. Chair, I do not understand how there can possibly be a $10,000 fiscal note here because the original language inflicts demonstrable bodily harm. That's a pretty significantly high level. But when you drop it down to on or intentionally throwing or otherwise transferring bodily fluids or feces at or onto any of the following persons guilty of a felony, you realize with healthcare professionals, we deal regularly with bodily fluids and other such things on a regular basis. This could be a huge number of people who will have had this. To think that this would be $10,000 just does not make sense to me.
Any further discussion? Senator Latz.
Well, Mr. President, I'm not in a position, I'm not sure Senator Kiffmeyer is in a position to dispute the Department of Corrections projections as to the bed impact of this offense. And the Department of Corrections projects, I suppose, 2 beds, a 2-bed impact in this current fiscal year, 0.1 FTE equivalent, I think, so $10,000. So I guess we can either accept Senator Kiffmeyer's not believing the fiscal note, or we can accept our fiscal agency's projections as to what the cost would be, and it was based on the bill as written. So I'm prepared to trust our fiscal staff from the Department of Corrections on that. And our legislative,
Chair,
I think it goes through our legislative fiscal office.
Quickly to that point, I'm a
Senator Kiffmeyer.
senator here at this table who reads fiscal notes. I think we as senators have the capacity. Fiscal notes are not binding. Thank you, Mr. Chair.
Thank you, Senator Kiffmeyer. Mr. Turner.
Yes, Mr. Chairman, members. Yeah, it doesn't mean, I mean, because it's just one bed, it doesn't mean it would be that many cases. There would be, there'd be many, many, many felony level cases. Most of them would be serving in jail. Those that, I believe that this is a felony level that is not presumptive commit to prison. And that's why we only have 1 bed in 23 and 2 beds in 24 and 2 beds in 25. It doesn't mean that there wouldn't be many, many convictions. It just means that they wouldn't rise to the level of being committed to the commissioner.
Senator Anderson.
Mr. Chair, what's the definition of a healthcare professional? Is it in the bill? As to, what, does it make, are they nurses, are they APRNs, are they janitors, or people work in the healthcare? Who are we designating here as a healthcare professional? Just asking if the bill recognizes that.
Mr. Backus.
Mr. Chair and Senator Anderson, the bill does not define that. If you look on line 2.9, it simply says, or other person providing health care services. And then, of course, in a hospital emergency room, department is stricken. So it's not defined in the bill or in the law.
Thank you.
Mr. Chair?
Senator Kiffmeyer.
Yeah, I certainly agree that anybody who intentionally throws or otherwise does this action of bodily fluids and so on, there should be consequence to that. Felonies, I think that's such a high level, that's what you're going to end up with, almost no consequence, because it would have to be a felony level and go to prison. And there should be a consequence, but making it a felony and that huge number of people as well, I would rather see a more meaningful consequence. But many times these folks are mentally ill or are sick in general. I worked in OB, and I want to tell you, there have been a few things thrown around in the OB floor when you have a very stressful type time. Are we going to now be having questions there? I think that what does transfer, so I think you have a nugget of something good, Senator Latz. But I really have just serious questions about felony. How effective is this going to be if you're only going to get maybe 2 convictions out of it? And, but I think no person should in any way, shape, or form be subjected to suffering that sort of thing while they are caring for patients as well, or in school districts or anywhere, to tell the truth.
Thank you, Senator Kiffmeyer. And so would this also apply then, Senator Latz, to a situation where somebody's having a mental health crisis, and, which that realm is really growing nowadays. We see that in our schools and communities, the mental health issues that are going on. Would that include those individuals that are going in for mental health treatment that may not be necessarily culpable of the actions that they are, or cognizant of the actions that they're taking at that time too? Would we be able to hold them to that same standard then, or how does that work?
Mr. Chairman, they would be able to avail themselves of the mental illness defense and would undergo a Rule 2002 evaluation to determine if they were culpable, just like any criminal defendant would be eligible to. I think it's also fair to say that our prosecutors would exercise their discretion in what charges to pursue as well under those circumstances.
Thank you. Any further discussion? Senator Limmer.
Mr. Chair, I'm looking at the remainder of this amendment on section 22. The discussion was whether or not this action deserved a felony conviction. Above the new language, there is a condition which says inflicts demonstrable bodily harm. I think that's a higher standard than just a common simple assault. Maybe Mr. Backus could explain what that means.
Mr. Backus?
Mr. Chair, members, I think it's something that gets used to distinguish a crime so that it has to be a physical assault. So in other words, it's not the assault where you intend to cause fear in someone, but it's actually some type of physical altercation. In terms of how it's defined, it's fairly low level. I think it's any type of, maybe, it has to be something you can see, obviously, so maybe some type of bruise or scratch or something like that.
Thank you. Senator Limmer?
I have a question for Senator Latz. Senator Latz, on 2.9, we've stricken the language in a hospital emergency department. Does that mean that this person could, if they received demonstrable bodily harm by someone throwing something at them on their weekend off, are they going to get the same penalty? Or is it the operative words, while providing healthcare services?
Mr. Chairman, Senator Limmer, those are the operative words, while providing health care services.
Mr. Chair,
Senator Limmer.
this is one of those bugaboos that we deal with in the legislature all the time, and it's an evolution of activities and professions that keep adding onto this list. It's one of those things that makes my skin crawl, because every time, first it started out with police officers, then it went to prosecutors, then it went to judges. I think correction officers are in it. Those were intended to be people of authority that were imposing the possibility of the state's power on taking their personal freedom away because of their actions. Now we're getting into a different category of employment, which the person, as important as they are to an individual, they're not quite the same authority figure as what we have in law. I'm going to begrudgingly accept this language because it's not going to go away. It just keeps coming up every year, and I don't think we can avoid it. But I'm going to caution everyone that listens to this is pretty soon the only people that won't get an enhanced penalty are average God-fearing taxpayers that are not working anywhere. And then they're the ones that get, if they do something, then it's just a completely different standard. And I hope we could keep it focused more on a person of authority that's trying to do something in that vein that I had mentioned. But Senator Latz, I'll accept this language as a friendly amendment.
Thank you, Senator Limmer. Other members' discussion? One aspect that I do want to hit on here too, that staff has pointed out, is that, Senator Limmer, you mentioned while providing healthcare services. However, the while is not included within 2.9. So just wanted to see if that changes anything in your comments about that.
Mr. Chairman, Senator Latz, would you consider amending your language and insert the word while?
Senator Latz?
Mr. Chairman, I would ask council for guidance on whether that is a legally significant change or omission, whether it makes any difference if the word while is in there or not.
Mr. Backus?
Mr. Chair, members, I guess I don't have a definitive opinion on that. It's just how you read it. I guess I interpreted it as currently drafted as it would modify, it would include while. Yeah, so I guess I can't arbitrate that for you.
So, Senator, or Mr. Backus, it would include maybe the act of doing it, but it doesn't exclude a person who's just in the industry and not acting at that capacity at that time.
Mr. Chair, members, again, if the committee thinks that adding while providing gives more clarification, I wouldn't dispute that, or, I really can't say either way. It depends on how you read that.
Certainly. Senator Latz, would you be willing to entertain that?
Yes, Mr. Chairman, certainly if that'll make Senator Limmer more comfortable as well, I will incorporate in my amendment on line 2.9, after person, insert while.
Very good. Any further comments, questions? Senator Limmer?
Mr. Chairman, just so I'm getting a clear knowledge, the word intentionally on lines 2.4, that still remains, does it not? All right.
Senator Limmer, could you repeat that?
Pardon me?
Could you repeat that?
I was just asking for clarification, Mr. Chairman, that the word on lines 2.4, the word intentionally is still in the amendment, and I've been told that
Yep.
it is.
Good. Oh, Mr. Backus?
Mr. Chair, considering this, if the committee is intending to insert while, I think it might be a good idea to put comma while. That way, I think it'll be clear that it applies to all three, both the physician, the nurse, or the other person while they're providing it. So that would be extra clear that, say, a physician isn't covered just by virtue of being a physician, like in, when he or she's not actually acting as a physician.
Thank you. Senator Latz, would you be willing to accept that?
Yes, Mr. Chairman.
All right, we've made a couple of changes on the A36 amendment. Could we briefly just review the changes that were made prior to adoption? Mr. Backus?
Mr. Chair, members, it would be delete lines 1.3 to 1.28, and then on line 2.9, after person, insert comma while. So the only provision being added to the bill would be on page 2.
Yeah, delete it from here to here.
Did you say that?
He did the lines, yeah, line to line, yeah.
Sorry, Pappas, are you comfortable with that? Okay. All right, members, see no further discussion on the bill. All those in favor say aye.
Aye.
All opposed? Amendment is adopted. All right, on to the A5
Mr. Chair,
as amended. Senator Begum.
thanks. I would offer the A20 amendment.
Senator Begum offers the A20 amendment.
Thank you. This amendment is regarding the Interstate Compact for Adult Offender Supervision, which regulates the interstate movement on adults in probation and supervision. And I believe Senator Limmer and I are both on this commission. It's enacted in every state, and in Minnesota, there's an advisory council. And the council works with the national governing body to ensure compliance, and the compact is also required by statute to issue annual report to the legislators and governors. And in Minnesota, as in other states, advisory council and committee are combined as one. Advisory council do the implementation of both the adult and juvenile compacts. And so what this amendment does, the council's recommended this bill. It's a technical bill in order to streamline membership and codify current practice where the meetings of the councils are held jointly in one report, which would obviously cover both the adults and the juvenile areas, and that's submitted annually. This is a technical bill. Representative Mueller has it. She's one of the House members. So just trying to help clean up the advisory commissions and get in line with what we need to. That's the amendment.
Thank you, Senator. Further comment, questions? Senator Kiffmeyer.
Thank you, Mr. Chair. So this whole article is an Interstate Commission Advisory Council. Is that correct, Mr. Chair? Is that the only issue? And this is quite a number of pages.
Mr. Chair.
Senator Kiffmeyer, I'll refer that over to Senator Bingham.
Yep, thanks.
Yeah.
Senator Kiffmeyer, yep, so it's just the technical changes that the council has recommended. So a lot of this is just updating technical changes to current law to reflect the combination, combining of adult and juvenile compact, and then also for efficiency, putting it into one report.
Mr. Chair, do we have a interstate commission on juveniles already established, or is that, because sometimes it's referencing that and it's actually something new?
Senator
Mr.
Bingham.
Yeah.
Yeah, Mr. Chair, Senator Kiffmeyer, yes.
Thank you. Senator Kiffmeyer, follow-up?
Well, Mr. Chair, again, anytime, as my staff told me on state government, whenever you have something where it affects the council and is changing the members or the makeup of something such this, it needs to go to state government committee. And I don't recall seeing this. Maybe it's supposed to be re-referred to it. I'm not quite sure, but I do know from what I'm seeing of this right here, that would fit the requirement that it go to state government.
Senator Bingham?
Well, I have nothing. This is
Okay, I thought you were-
technical and just needs to be combined. It's not a big deal.
Mr. Chairman.
Senator Limmer?
I'm not on the membership of either of these councils.
Oh.
And unless I've really missed a lot of meetings,
My apologies. I thought you were, Mr. Chair.
that's all right.
I am.
Gee, I don't know what to do about this. Senator, since you're knowledgeable of the idea that it's already in the other chamber's bill, I would suggest we pick it up in conference rather than today. So I would oppose the amendment.
Senator Bingham?
I mean, actually, Senator Limmer, you might be on one of the committees. I think I'm on juvenile, you're on the adult. So, I mean, I don't know, we're supposed to be part of these compacts. I don't believe the House, it was heard in state gov because of the jurisdiction of where these councils are. It's in public safety. I mean, I don't know. Yeah, there's nothing new. We're just combining it so that it's more efficient. We're doing one report. This is about efficiency in government, so.
We've done we've done a number of these compacts this past year too, and I'm a little surprised there's not a preamble that we can take out of this one. That should be the first thing that we do on this. But I am unfamiliar with this at all and have not been in this area, but it is in the present omnibus over on the House side. That's what I'm gathering right here?
Yes, Mr. Chair, yes, it is. And I do have the 2021 compact report, which does, I believe, I'm going to scroll down here, but I believe it does. I mean, I could forward it to folks, but it definitely,
Yeah. and Senator
definitely
Bacon.
lists both Senator Limmer and I on the report. It's just confirming, so I wasn't misleading people. So I don't know, Mr. Chair, I'm actually quite surprised that this is having this much of an issue. It is about, both of these are established. This isn't a compact as in what you referred to, like SIPAC or the Nurses Compact. These are advisory councils on supervision. We're combining them for efficiency, and then we're also combining the report for efficiency. This was recommended by the national conference that kind of works through all this stuff. And I know that both of the councils approved it. So I literally, this is my shock look face, because I didn't think it would be a big deal. I thought this was an easy one.
Mr. Chair,
Senator Limmer.
I haven't talked to anyone from the Council on Interstate Adult Offender Supervision or Interstate Commission for Juveniles. I don't know if both groups are in favor of this. I don't know what the impact would be. Is there a cost saving? Maybe. It seems harmless enough, but I also know we have a couple more stops before we get to the end of the year. And I'm open, I just need more information.
Mr. Chair?
Senator Bacon.
Yeah, both councils have approved this to be recommended to be joint so that they can have this efficiency and do the one report. So that's.
So, Mr. Chair,
Senator Kiffmeyer.
no matter what, we have the Senate rules in regards to this, and that may have been taken care of in the House, but not here in the Senate. And so it's the jurisdiction of the State Government Committee to do these things, and no matter how simple someone thinks it is or even worthwhile, may be the case, but nonetheless, the state government that has jurisdiction on these memberships and all of these things should be seeing this and using the advantage of our general counsel that we have in our committee, who is way more knowledgeable about these things, and that's why they go to state gov. So you have the advantage of those staff. It may be that Senator Limmer might in the future consider that, but in the meantime, I would just caution against taking this on.
Mr. Chair.
Thank you, Senator Kiffmeyer. Senator Bacon.
When I meant by council, I meant the two national advisory councils, not our council here in the Senate or in the House. So it's the two national councils that we deal with this when we have transfers of adult probation folks, juvenile probation folks, like, I mean, that's what I'm talking about. I'm not talking about inside here. The other body is moving this bill, and it is, I believe, in somewhere in the process there, somewhere between probably Judiciary and Ways and Means.
Thank you, Senator Bacon. And I do know that the compacts that we've had in this committee this year and in past too, they're typically very active with members on approaching us on and explaining what is going to happen within the compact prior to any committee hearing and work with us very closely. So to see this right here today, I have not been approached by this. So personally, it's probably great and we'll go on without any amendments or anything, but I don't know what this necessarily impacts or what the repercussions of this are going to be. So although we can take your word for it and clearly just vote for it, but I am just as shocked, this is my shock face, that this is coming to us without any sort of warm-up before the committee on it. So,
Mr. Chair,
Senator Bacon.
It's because it's not a, I just said this, it's not a compact as what you're referring to. This is a national council that each state has, so they can do interstate transfers of adult and juvenile probation folks. And actually, there's money in this bill to help pay for that. So these are things we've been part of. We're not changing any of that. All we're simply doing is for efficiency, naming, combining so that, which is the request of the national council. And I'm finding out that I think Senator Limmer's been on since 2017. So this is something we appoint as Senate members get appointed to these national councils. And all this is their technical recommendations to do this and combine the report.
Thank you, Senator Bingham. Any further comment, question? All right. Senator Bingham moves the A20 amendment. All those in favor say aye.
Aye.
All opposed? No. Amendment fails.
Mr. Chair,
To the A5.
Mr. Chair,
Senator Bingham.
I'll offer the A21 amendment.
Senator Bingham offers the A21 amendment. To the amendment.
Thank you, Mr. Chair. This is a bill that passed near unanimously last year. This is Senator Rosen, Senator Limmer, and my bill increasing the penalties for fentanyl, carfentanil. This is an epidemic, members, in our communities, and this is a tool that law enforcement needs. It's been recognized and supported, this bill, by the Minnesota County Attorneys Association. Senator Rosen, Senator Limmer, and I have authored this bill now for a couple sessions. It's needed. I think it's going to be extremely helpful to have in the omnibus bill for further on down the road. I wholeheartedly support this bill because we need to give tools and equity when law enforcement and prosecutors are charging out these crimes. So I would appreciate members' support.
Thank you, Senator Bingham. Members? Senator Limmer?
Mr. Chairman, Senator Bingham, is this the exact wording that we passed on the Senate floor last year?
Senator Bingham?
Mr. Chair, no, this is the exact wording of the new bill that you, Senator Rosen, and I just introduced like a week or two ago.
Okay.
So it has the technical tweaking fixes that the county attorneys had suggested.
Yeah, we didn't have this application in our budget. Is there a budget cost to this bill?
Mr. Turner?
Mr. Chairman, members, yes. Fiscal year '23 cost to Department of Corrections of $9,000, 24, $15,000, 25, $25,000. It'll max out in 10 years at $42,000 a year.
Further questions? Senator Matthews?
Thank you, Mr. Chair. Question for Senator Bingham, since we passed it last year. I assumed it had been taken care of, signed into law and all of that. What's happened in the other body?
Yeah.
Senator Bingham?
Senator Matthews, it was the other body. They didn't like it, so we got to bring it back.
Can they still pass?
Any further questions? Senator Pappas?
I just wanted to mention that I believe I heard in the news that someone was just convicted of selling fentanyl on the internet. It was supposed to be some other drug, but it was actually fentanyl, and killed 8 people as a result of that, and got sentenced to 30 years in jail. This is very, very serious drug. And that, you know, they were able to, I'm not sure if that was a Minnesota person. They were able to convict without this bill somehow, but this will make it a lot clearer and cleaner.
And Mr. Chair, to that point,
Senator Bingham.
I have constituent in my, actually a few where unfortunately their children have died from fentanyl poisoning because of receiving it on Snapchat, and it's just tragic. So this, and the dealers, these hardened criminals that are perpetuating that this is a, you know, an Oxycontin pill, but it's laced with fentanyl. I mean, it's just horrific, and we need to, you know, we need to address that. This is one of the tools in the toolbox, and I will say, Senator Limmer, if there's a fiscal note, you're the chair of this committee, Senator Rosen's the chair of the Finance Committee, and I think we can probably, the three of us, figure out how we can get that. But, Mr. Chair, we need to get this passed again and bring it back through and sign it into law, get it passed and get it into law.
Thank you, Senator Bingham. Senator Matthews.
Thank you, Mr. Chair. So just following up on my other comment, I mean, yeah, I'm pretty sure we're all unanimous on this issue. There's budget implications if we added it into our bill. If we want to get it done, the way to do that is not repassing it in the side that's already passed it. It's getting the other body to decide to take it up and pass it. So I don't know if it is properly in this bill, or, you know, it's up to the chair, I suppose, for what the budget pieces should be, but what I'm gathering is the Senate, we've already done our job. And I think the people we need to be talking to is not just the other senators here, it needs to be the House leadership as to why they've decided to not take it up.
Mr.
Thank
Chair.
you, Senator Matthews. Senator Bingham.
Totally agree with you, Senator Matthews. That is one way that we could get this passed, but the other way is to do what we did last year, which was bring it into conference on that as well. So, you know, dual tracking this is I think a very smart way, but I'm telling you, daily these stories come into the media, and we need to address this, and you know, hopefully a year's passed, unfortunately, so have a lot of Minnesotans due to fentanyl poisoning, and so we've got to tackle this deal, and hopefully this time around, Senator Limmer will be luckier on getting the other body to agree with this. But I think it's wise to bring it in and continue to fight it. And I appreciate the relentlessness that Senator Rosen and Limmer have shown on this issue. But this is just one angle to tackle it. But we need to pass this.
Seeing no further comment.
Mr. Chair.
Oh, Senator Limmer.
Mr. Chair, I remember talking this bill over with Senator Rosen. I thought it was her intent to carry the bill separately, simply because, as has already been said, we already had a single vote on it, and she didn't want it to be included in the omnibus. I think I'd defer to her authorship on that. It's not going away. And the House, all they have to do is pull the bill up and vote on it. So I would rather, just on a process standpoint, prefer that it would not go into the bill.
Very good. Any further comment? All right. Senator Bingham moves the A21 Amendment. All those in favor, say aye.
Aye.
All opposed?
No.
Motion fails. To the A5.
Mr. Chair.
Senator Bingham.
I would like to offer the A22 Amendment.
Senator Bingham offers the A22 Amendment. Senator Bingham to the amendment.
So last year, we were able to, in the omnibus bill, pass the doxing provision for law enforcement because of incidences that have occurred at their residence. Now, a year later, we've seen very public, very public examples of the same situation happening where there's demonstrations and, in fact, invasions into buildings for judges and prosecutors. And so all this simply does is expands that doxing provision to include criminal justice official, and that is not only the peace officer, which we already have, but also prosecuting attorney, judge, person employed as a public defender or criminal defense attorney, so that's both public and private, or persons employed by the same office. So it's, the rest of it is, you know, just striking out law enforcement, put a criminal justice, and, you know, updating that code in accordance to statute. So I would appreciate members' support on this expansion of the wonderful bill that we passed last year.
Thank you, Senator Bingham. Members, any comments, questions? Senator Limmer.
Thank you, Mr. Chairman. Senator Bingham, I'm going to support this, but I think it needs an addition. I think a criminal justice official should also include specifically a correction officer or jailer. And perhaps Mr. Backus could add that. Oh, by the way, is there a cost
Senator
to
Limmer?
it? Predicated on the cost.
Okay.
Mr.
Senator
Turnus
Bingham,
is,
do you have
Mr.
fiscal
Turnus is saying no
impact?
cost.
Mr. Turner, no. Mr. Backus, have you had ample time to think about it, or would you like a few minutes?
Mr. Chair, well, if you gave me more time, I might be able to look up something and try to actually get a definition or something, but if you wanted to, you could put on line 1.10, delete or, and insert comma, a correctional officer, comma, or. So it would read, a person employed as a public defender, correctional officer, or a criminal defense attorney.
You know, we could pull this amendment, give you some more time, but I'm afraid this is our last amendment of the day, right? Oh, okay.
Nice try.
Any further thoughts? Senator Anderson.
Could Mr. Backus reread the amendment?
Mr. Chair, members, line 1.10, after defender, insert comma, correctional officer, comma. So it would read, as a public defender, comma, correctional officer, comma, or a criminal defense attorney.
Everybody clear on that? Thank you.
Mr. Chair, I would incorporate that as a friendly amendment.
Okay.
Mr. Chairman,
Senator Limmer.
question to council. Mr. Backus, does a deputy sheriff working as a jailer fall into the correctional officer definition?
Mr.
Mr.
Chair,
Backus?
members, that there's no definition of correctional officer, so I guess if I had to say, probably not, because I don't think that person would be a correctional officer.
But
Senator
the, oh, I see, Mr. Chairman, on 1.8, it does refer to a peace officer, so peace officer is still a peace officer, even though they're working as a jailer in a county sheriff's jail.
Thank you.
Mr. Chair, that's a good point, Senator Limmer.
Okay. Thank you, Mr. Backus. Senator Limmer. Any further comment? With that, Senator Bingham moves the A22 amendment. All those in favor, say aye.
Aye.
All opposed? Amendment passes.
And then,
On to the A5.
Mr. Chair,
Senator Bingham.
I am going to offer the A44 amendment, but I am going to, I don't want to include line 1.3. So I don't want to insert 12 million. I want to leave it as is. And if I'm incorrect on how I'm framing that, Mr. Turner would correct me.
All right. let's get the A44 amendment in front of us. Senator Bigum moves the A44 amendment. Senator Bigum, to your amendment.
Sure. Mr. Chair, what this amendment does is as a lot of folks know, I've been trying to work on this body cam thing because it's a big, whether it's for the devices or for the storage, it's a big deal for our local sheriffs and cities. We know that 50% of the departments do not have them. I've been working with Senator Duckworth on how we can kind of get through all of this. The one thing I would like is to not have the local match. That is a big impediment to them starting the body cam program. So that's part of the amendment. The second part is, Mr. Chair, both of the counties that I have the privilege of representing, their correctional officers in their jails have body cams. And so we need to include that language in this bill so that they also could be, that's a trend that's moving forward. And so that's just word that they would be an eligible expense, that occupation would be an eligible expense. And that's the amendment, and I took out the money because I just, the increase in money, because I will let Senator Limmer figure that out in the Finance Committee. So this is just the wording part of it, that I'm adding local correctional agency to that so that correctional officers in our local jails can have them if their department chooses. And then also the local, getting rid of the local match.
Thank you, Senator Bigum. Any comments, questions? Senator Limmer.
Mr. Chairman, by removing the match, that means there will be, and without changing the dollar amount, there'll be fewer agencies that will be eligible for this funding, in addition to the fact that it's going to be diluted by the number of local correctional agencies as well. And I don't know how to compute that. I don't know if Mr. Turner can either, so I'm not sure if we're reducing, in the intent that you want, it may be reducing the dollar amount down to a figure that may not mean a whole lot to a lot of agencies.
Yep. Mr. Turner.
Mr. Chairman, members, I believe that what Senator Bigum was doing is that she originally had $12 million, which was over doubling it. And that was, eliminating the local match and including local correctional agencies. I think what she's saying is that the way things are going with money today, that she understands that the $5 million will go to conference and perhaps be increased in conference committee, would be my take.
Mr. Chair, Senator Limmer, that is exactly my intent. So that these should be considered an option for the local correctional agencies. And then also, I think not having the local match, of course, that means that the state is going to have a larger expense for it. I mean, that's why I put the money in originally. But based on again, how the committee is kind of reacting to the money side of things, if it's an open appropriation, then you can figure that out in finance as we're trying to help cover all of our bases in law enforcement and in corrections.
Thank you, Senator Bigum. Members, any follow-up?
Mr. Chairman.
Senator Limmer.
It looks like there's a whole bunch of other things here, like peace officer bonus programs, some changes in 609 being added for inmates serving mandatory life sentences.
Senator Limmer, are you on the A44 amendment?
Oh, I guess I'm not.
Okay.
I'm sorry.
I was like, what is my amendment?
I was correcting the A5, and then I just kept on going, so sorry about that. quite honestly, Senator Bigham, I think this would be more appropriate to consider during a budget year than, because, you know, take for example, local correctional agency, usually that means a sheriff's jail. And since they're already local law enforcement, they would be eligible for that funding anyway. So it's just confusing. I just think that it would be better left for a budget year, and we may have a little larger official target at that time, first year in a biennium.
Thank you. All right, members, see no further questions. All those in favor of the A44 amendment, please indicate by saying aye.
Aye.
All opposed? No.
No.
Motion fails. Back to the A5. Seeing no, oh, Senator Latz.
I know, April Fools, right?
Oh, yeah, we can use that today, can't we? Thank you.
Mr. Chairman, I'd like to offer the A49 Amendment. I hope members now have a copy of it.
They'll be passed out here, members. While it's being passed out, why don't you describe it then?
Thank you, Mr. Chairman and members. The A49 Amendment addresses the terms and conditions of release from custody pending criminal proceedings for people who are arrested for gross misdemeanor or felony DWIs. Gross misdemeanor DWIs being first offense with a .16 or higher test result, or repeat offenses. Current statute requires that they be given two options: a no conditional release option of bail only, which would be $12,000 max bail. Alternatively, they would have the option of a conditional release, including a condition requiring alcohol monitoring while they are released to ensure their abstinence pending the criminal proceedings. Right now, counties and courts do that alcohol monitoring in a variety of ways, either with a color wheel or a number that comes up. People call in, they get notified they have, if their number or their color is up, they have to go in and get tested for alcohol use. Or in some counties, including Hennepin County, they have a remote electronic alcohol monitor, which is affixed to their ankle, which detects alcohol use through the skin. The ignition interlock program is also an important public safety program available to those in the same situation, those same DWI arrestees who lose their licenses but can get their driving privileges reinstated promptly if they install the ignition interlock device into their vehicle and drive only that vehicle. That interlock device monitors alcohol consumption. In fact, they cannot start their vehicle without blowing into the device that's installed in the vehicle and having a zero alcohol reading as a result, a negative result. If they have a positive result, that is recorded in the data associated with the interlock device, which is eventually reported to the provider and to the Department of Public Safety, Driver and Vehicle Services, that is monitoring ignition interlock. The interlock device requires, or the program requires, that people blow into the device. Typically, it's on a regular basis. My proposal here is for those who are subject to the conditional release following their DWI arrest of electronic alcohol monitoring or alcohol monitoring, that they be given the opportunity or the alternative or the option of having that monitoring conducted through the interlock device if they choose to install one, rather than through either the color wheel or a number system or an electronic ankle bracelet that monitors their alcohol. If they do both, and many of them do because they want to be able to drive to and from work and to take care of their families, so they pay the $250 or $300 installation fee, they pay the $150 $25 or so per month maintenance fee for the interlock device, and they're also paying, in Hennepin County, about $7 a day for the alcohol monitor on their ankle. It ends up being, in my analysis, quite duplicative, an inefficient use of resources, and for some people, a real financial barrier or impediment or burden for them, especially as their cases can last 2, 3, 4, 5 months. That's especially cogent coming out of the pandemic delays, in which even cases now on first appearances, sometimes the next appearance will be scheduled in June or July or August. So depending on the court calendars, at least that's the Hennepin County experience. So, if someone is spending $7 a day, that's, about $50 a week. It's almost $200 a month to have the ankle bracelet on monitoring their alcohol, while at the same time they're driving to and from work every day. It would be a simple matter if the judge had the option under the statute, either immediately at the time of their release, or while they are released, after they, excuse me, install the interlock, to substitute the interlock as the alcohol monitoring device for the other methods of conditional release that are currently allowed in the statute for alcohol monitoring. The judge could set the conditions any way he or she chose to do so. They could require an individual to blow into the interlock device 1 or 2 or 3 times a day. The interlock providers, who already have an obligation to report results on a regular basis to the Department of Public Safety, would, under such circumstances, then set up an agreement with county probation departments as well to report positive test results from the interlock to probation so they could monitor any violations of the conditional release terms. So that is the core feature of this amendment. There's a second component to it, which you'll find on lines 2.11 to 13 and also on 2.17 to 19, relating to choices of vendor. There are some counties, excuse me, that are steering defendants who wish to do the interlock to one particular interlock vendor without making clear to the defendants that they have an option of either 6 or 7 authorized vendors in Minnesota to do so. In effect, freezing out the marketplace in favor of one preferred vendor in that particular county. I have heard specifically of probation officers going to people in custody and saying, you should get interlock, why don't you call so-and-so? It doesn't seem to me that that is fair, nor is it appropriate in that regard. And so the additional provisions I've indicated in there are both for the conditional release terms that I've already described, and also for any other circumstances in which a judicial officer, a county agency, or a probation officer may be interacting with a person who might benefit from the Ignition Interlock program. It would be inappropriate for them to refer or give information or steer that person to only one interlock provider. The idea, or to a particular interlock provider. I think the best practice would be to say, here are the list and phone numbers of the 7 authorized vendors in Minnesota. You can call any one of them and determine for yourself if you what would work for you in terms of installation, time, location, cost, and so on. So that's the 2 pieces of the amendment, and I'd be happy to answer your questions. I hope you'll find it meritorious.
Thank you.
Mr. Chair.
Senator Kiffmeyer.
Thank you, Mr. Chair. In listening to Senator Latz, what he's saying here is that no employee, I would gather, can make a suggestion or require to use a particular ignition interlock device program vendor, I'm guessing, But the example he used was saying it'd be better to give a list of the approved ones. I would agree, but that's not what this bill says.
Senator Latz.
That's correct. I'm not proposing in the amendment to mandate that a full list of all the vendors be provided, although I'd certainly be open to that. I think that might be even a better way to approach this, Senator Kiffmeyer. Appreciate the thought on that. But my main concern was that it appears that some counties are steering individuals to one particular vendor and freezing out other vendors from equal opportunity in the market. And that seemed to me to be inappropriate in and of itself. But I'd certainly be open to putting a provision in that said they should provide a list of all authorized vendors and contact information. Leave it at that.
Mr. Chair,
Kiffmeyer.
it's Senator Latz's amendment. I think if that's what he wants to do, he should propose such.
I will ask counsel to help me prepare language to that effect. Appreciate the suggestion, Senator Kiffmeyer.
Just a quick question on that. So I don't know the reputations or how many companies there are of the interlock systems right now. But if a county or an individual was having trouble with a certain company or has had trouble in the past with them and would not want to participate with that particular company, would they be able to keep them off the list in that case? Or, you know, for just professional reasons, you know, be able to do that? Otherwise, you have to hand them the list and they could sort through whichever one they want to do. Senator Latz.
Yeah, Mr. Chairman, the Department of Public Safety went through a pretty extensive certification process to authorize certain companies, certain vendors to meet all of their standards in terms of quality, in terms of meeting the statutory criteria for what the devices can do. For example, the device has to have a camera. So there can be a facial identification of the person that's in the driver's seat blowing into the device, providing it, so you can't get someone else to come in and substitute, you know, a clean breath sample. It's got to have the capability of sending that information, maintaining the information, sending it to the vendor, which can go to the department, all these technical criteria. And these are by and large national vendors using at least nationally used equipment. So any concerns about whether a vendor is not meeting at least the minimum criteria defined by the Department of Public Safety could be directed to the department, and I'm sure there's a process by which either complaints can be resolved or consideration of whether to revoke that authorization is appropriate.
Mr. Chairman.
Senator Limmer.
While council is preparing that amendment, Senator Latz, is any of your amendment approved by the DWI task force?
Senator Latz.
Mr. Chairman, no, we have not had an opportunity to go through the task force process on this. I will note that, excuse me, that they were strong supporters of the interlock program, as frankly all of the law enforcement community was, and the Department of Public Safety. When I carried the pilot program and when we made it a statewide program. But no, we have not had an opportunity to run through that process at this point. Were the committee to accept this amendment today, I would certainly be willing to transmit this to the DWI task force and seek their input explicitly on this amendment prior to any conference committee on the bill, so we'd have the benefit of that input as well, Senator Limmer.
Mr. Chairman, do we have anywhere else in law where we prohibit a suggestion from a person? I know this is perhaps a requirement of the court when it comes to these type of devices, but do we ever do that elsewhere in law? I can see where it would may not require language, but just the word "or" suggest. What if you had someone, oh, my uncle uses this one, that might be good. That would be a suggestion. is that bad? That's the question I would ask.
Sarah Lance.
So, Mr. Chairman, I should probably ask counsel if he's aware of any other places in law where we do that. I can't think of one specifically. But I think, you know, if someone were to call us, you or me, and ask about it, we said, oh, my uncle uses this one, I think that'd be helpful to you, or you know, what I do, you know, with some of my clients, I have suggestions for them. But I think it's different if you're a person with legal authority in some way connected to the individual. If you're the judge in the case, that might be a problem. If you're a probation officer who has the ability to revoke someone's probation or to violate someone's terms of conditional release, I think that show of authority is problematic, even if you're making an offhand, informal suggestion. Just the appearance is troublesome, and it does create probably some unseemly incentives in the system as well.
So, council has asked for a little more time on this particular bill to draft the proper amendment on this. Perhaps what we should do for right now is we could either withdraw the amendment if you had any others. Otherwise, if this was the last one, we could just wait for a little while.
Another April
but
Fool's joke.
Judging by the smile, this will not be the last one. So could we do that then? Just withdraw this for a moment. We'll make the motion again, and then we can move on to the other. In the meantime, we'll move on to another conversation.
Of course, Mr. Chairman, I'll withdraw the A49 amendment for now. I'm the only one left with amendments.
All right, we are back on the A5.
Okay, Mr. Chairman, council would like to chat with me for a moment about the draft of the amendment.
Certainly.
And I think I'm the only one left on my side over here with amendments, so I'd ask if we could take a moment so I can speak with council.
Sure. Let's take a 5-minute break here,
Thank you.
and we are in recess. move the A49 motion.
Move the A49 Amendment, motion, Mr. Chairman, and council and I and Senator Kickmeyer have consulted, and council has a suggested amendment to address this issue.
Senator, or Mr. Backus.
Mr. Chair, members, it would be the same language added in two different places. So on line 2.13 before the period, and also on line 2.19 before the period, insert, but may provide the person with a list of all Minnesota vendors of certified devices.
Mr. Backus, would you repeat one more time, please?
Yes, Mr. Chair, members, line 2.13 before the period and 2.19 before the period, insert, but may provide the person with a list of all Minnesota vendors of certified devices.
Thank you.
So, Mr. Chairman,
Senator Latz.
I incorporate that language into the A49 Amendment.
Right. So the amended language is incorporated. Any questions from members? Wonderful. All right, any further comments or questions to the A49 amendment?
Mr. Chair, oh, that was an incorporated amendment?
That was incorporated into the amendment.
All right. Senator Latz, I did have a question regarding the body of the language. Do you know are we dictating to the court again, or are we giving them an option on May, if you will?
Senator Latz.
Well, Mr. Chairman, I suppose to the extent that we have the authority to do so, we are stating a prohibition on a court steering a person to a particular vendor. Suppose if a court felt that we didn't have the authority to do that and they wanted to direct a person to a particular favored vendor, they could do that if they wish. I'm not sure who would end up challenging that. It would still appear unseemly to me if they chose to do that, but.
Well, I see that the language, Mr. Chair,
Senator Limmer.
2.5, a court is not required. So I suppose that's a little bit of an opening there. It's not a strict direction, nor is it a strict prohibition. Is that correct? Is that how you read it, Senator Latz?
No, Mr. Chairman,
Senator Latz.
Senator Limmer, I read it as a prohibition on the court suggesting or requiring that a person go to a particular interlock vendor.
Senator Limmer, follow-up? Members, any further comment, discussion? Senator Limmer?
Senator, or Mr. Chair, I guess I'm not that well versed in this area of law like Senator Latz would be. So I really can't give comment too much about it. I think I'm just going to have to leave it up to the committee to decide. Unless you can give me more definition of what the body of the language is. I'm not too concerned about the choice of vendor down below, starting on line 217. I'm more concerned about 213 and up, that paragraph.
I'm sorry, I didn't hear that.
I'm more concerned about the language on 2.5 through 2.13.
Okay, so, Mr. Chairman,
Senator Latz.
within that language, there are two components. Starting on line 2.11 with a judicial officer, that language is identical to the choice of vendor language down on 2.17.
I understand that. Let me revise
It
my
sounds to me-
concern. 2.5 to 211.
Okay, so then, the point of that language there is to, when a DWI defendant appears in front of a judge on the first appearance, having been arrested for the gross misdemeanor case, being subject to the mandatory bail or conditional release requirements of this statute. Right now, the judge has only two options. Maximum bail of $12,000, either cash or bond, or alternatively, conditional release. But that conditional release must include an alcohol monitoring program. The purpose of this amendment is to give the judge a third option, either at that point in time or sometime during the pendency of the case, to allow, instead of that current alcohol monitoring program, to allow the interlock device to be the alcohol monitor.
So, Mr. Chair,
Sarah
we
Limmer.
are not restricting a judge in discretion. We're actually giving them a third option.
Mr.
Senator-
Chairman, Senator
Senator
Limmer,
Ladd.
that's correct.
Wonderful.
All right.
Any further discussion on
Ms.
the
one
A49?
extra thing.
Senator Limmer.
Sarah Latz, if you could get some comment from the DWI task force before it gets to the floor, I'd appreciate it.
I will, Mr. Chairman.
All right.
Thank you.
I'm okay with the amendment, Mr. Chair.
All right, thank you, Senator Limmer. Any further comments? With that, Senator Latz moves the A49 Amendment. All those in favor say aye.
Aye.
All opposed? Motion passes. To the A5 as amended,
Mr. Chairman.
Senator Latz.
Mr. Chairman, I have the A27 amendment I'd like to offer.
Senator Latz moves the A27 Amendment. To the amendment, Senator Latz.
Mr. Chairman, I'm offering as an amendment a bill that we did here in committee, which relates to allowing the Metropolitan Council and Metropolitan Transit to issue administrative citations for fare evaders rather than criminal citations. Mr. Chairman, I think you have a letter from Chief Frizzell from the Metro Transit Police Department in your packet. But I don't know for sure if that was distributed or not. But
Senator Latz, staff says that we have not received it.
okay, then maybe I pulled it from a different folder. But I can highlight the points of it.
Okay, so this is something that's been. Okay, so this was distributed prior to today's hearing.
Okay, well, I don't expect everyone to remember what's in there, but I'll just highlight the reasons why the chief law enforcement officer for Metro Transit supports using administrative citations. Right now, a criminal citation can only be issued by a licensed peace officer, which means that Metro Transit is using cops with all of their training to be fare monitors. And that is a very inefficient use of resources for a number of reasons. One is there is a higher level of offenses of different kinds and more serious sorts on transit than fare evasion that those law enforcement officers, those licensed peace officers, should be working to prevent and to solve when they occur. And in fact, we had Sheriff Fletcher testified at this, that there were occasions when people would call Metro Transit and they couldn't get a prompt response from law enforcement from the transit police, so they called the sheriff's office. And they happened to have people nearby who would respond immediately or very quickly to issues at transit stations, for example, light rail stations. So if we were to authorize administrative citations instead of criminal citations, then the transit police could employ non-certified individuals to monitor fare evasion, to check for people on board who make sure they have tickets and so on. They could issue a citation with just a fine only associated with it, and at a lower expense than a certified peace officer or licensed peace officer would be. And those persons could also act as ambassadors to the public and transit riders, and could act as the eyes and ears for troubleshooting purposes if they see there are issues that are arising or may arise that would be a benefit from or require the involvement of the licensed peace officers, then they could call in for help. It would just put more people, more eyes and ears available to make the transit riding experience more safe as well as more enjoyable, and that would help ridership, frankly, as well. The fare non-payment citations would also no longer have to go to the courts. And currently, what they say is that only 3% of fare non-payment citations right now result in a paid fine. So you end up clogging up the courts with a lot of citations issued by sworn officers that rarely result in any fine payments. Whereas if you had an administrative citation available for use, you could have non-sworn officers giving the administrative citation. It would be a fine only, and it would not clog the courts, and is frankly more likely to result in a fine being paid. Chief Frizzell says the fine now is about $180. They would bring the fine down to a level that's more consistent with the nature of the violation. You know, a $3 fare, which someone avoids, and they end up with a $180 fine to pay. Frankly, they're just not going to pay the fine. So if they would bring the fine more in line. And frankly, the way they're saying they expect more riders as the system expands as well. And their fare enforcement demands on police officers would be expanding as the transit system expands as well, which would give them fewer resources to use on enforcing more serious crime or safety concerns. So for all of those reasons, Mr. Chairman, I would ask for the support of this committee to authorize administrative citation program for Metro Transit.
Thank you, Senator Latz. Comments? Senator Diffmeyer.
Thank you, Mr. Chair. I see the purpose and some of those things, but what I would draw folks' attention to is Section 1, how it is paid for. So when I'm reading here, Senator Latz's operating costs, transit safety, talking about remitting an amount to the council such that the total provided would be the total expenditures of the council for public safety monitoring and reporting under these new sections. So this would be an additional capturing of money from Anoka, Carver, Dakota, Hennepin, Ramsey, Scott, and Washington. Interestingly enough, Sherburne County, one of my counties, where this goes through, so the counties, in addition to paying a tremendous amount of money already for the support of what is increasingly being viewed in a not positive way and has issues, but now we're going to take more money from each county to pay for this. Have you talked about this with all of these counties, Anoka, Carver, Dakota, Hennepin, Ramsey, Scott, and Washington?
Mr. Chairman,
Senator Latz?
Senator Kiffmeyer, no, I have not, and honestly, I'm not sure if that provision is even integral to the administrative citation elements of the amendment. My main purpose here is to facilitate the administrative citation components, so maybe I will ask if council can assist in answering the question. As I'm looking at the amendment, perhaps starting with section 4 may be the core feature of what, and section 5, which requires a report on it, might be the key features here.
Well, Mr. Chair,
Senator Kiffmeyer?
this is a huge amount of language with a great deal of work involved in it, of not only monitoring the rail lines themselves, but the facilities, light rail transit facilities that include security cameras, other lighting associated, public address system, real-time active monitoring, and timely placement or, maintenance or replacement of malfunctioning cameras. Somebody's got to pay for this. I mean, I don't disagree that there's a lot of problems with the transit system, abuse of the system, damage to property and people. More importantly, huge amount of language here, citations, fees, quota for the issuance of administratives must not mandate quotas. But I mean, you just kind of, administrative citations, a person who issued it must pay a fine of no less than $35. So, Mr. Chair, I think for this committee at this stage, there's a huge amount of language. I think it points up an issue, no question about it. The transit entities have a problem, obviously, with crime and other kinds of things, but to put this in front of this committee at this stage and all of this language and then commandeer county money to be paying for it, certainly, I think these counties deserve to be included in this, and if you take them out, then how are you going to pay for all of this? It's a huge amount of money.
Thank you, Senator Kiffmeyer. Senator Latz?
Mr. Chairman, a couple of points in response, Senator Kiffmeyer. One is this bill, the language in the bill this bill was taken from, was voted in favor by the Senate Transportation Committee. And I believe that the provisions that Senator Kiffmeyer just was referring to would be within the jurisdiction of the Transportation Committee and not the Judiciary Committee. I think it came to us on referral from Transportation because of the change of the citations from a criminal to a non-criminal administrative mode. So the Transportation Committee, under the guidance of Senator Newman, had already approved all the language that you see before you in this amendment. And then it was heard with a full hearing in this committee as well this spring.
Senator Kiffmeyer?
Having heard it in transportation, I still stand by my questions and my concerns.
Thank you. Any further comments by the committee? See none?
Well,
Senator Latz?
Mr. Chairman, I'd be interested in Senator Limmer's input on this amendment.
Senator
Thank you,
Limmer?
Mr. Chairman. Senator Latz, I've had mixed feelings on this. And the reason why is we've been told we have a transit police authority that's supposed to be taking care of the safety of passengers on the lines. They don't seem to be given direction to ride on these places, and I've always wondered why. If there's a problem on a moving light rail train, the transit police are usually in vehicles, and they have to race ahead of the train to get to a spot where passengers embark. And then hopefully they can catch whoever's creating the problem. My concern is that these uniformed transit safety officials that are to be on the train or on the platforms are designated on page 2 as not peace officers or community service officers. So I'm not quite sure what their degree of authority is other than writing citations. And maybe they'd give direction to passengers. But I'm concerned a little bit about their safety if they don't have a full designation. I just think that perhaps the transit police should be assigned to some of these moving vehicles rather than sitting on cars nearby. And so I'm concerned about the safety of these individuals that we would place on the trains without proper authority. And so I've had mixed feelings about this whole project.
Thank you, Senator Limmer. Senator Latz.
Mr. Chairman and Senator Limmer, I appreciate your expressing those concerns. I did just receive a text from a Met Council staff in response to Senator Kiffmeyer's concerns that the program here would be paid through fiscal year '25 in the Met Council budget using federal relief funds, and that the language that Senator Kiffmeyer is referring to is language that Senator Newman himself added to the bill when it was in front of the Transportation Committee. And then the Transportation Committee specifically approved that language. With regard to safety issues, I don't know how to respond to how the Met Council, the Transit Police disseminates its police officers. I'd be surprised if there was some prohibition on their licensed peace officers riding the transit to police them as well as being present at the stations. But I would respectfully suggest that enabling non-licensed individuals to issue citations, first of all, of course, they'd be trained. That just because they don't have a peace officer's license doesn't mean they wouldn't be trained to how to interact with public and others who they are suspecting of not paying fares. But it would free up the licensed peace officers to go to where their need is most, where it's most needed. So I think the opinion of the police chief of Metro Transit is that this would actually make transit safer for everyone. Safety has obviously been, reducing crime, preventing crime has obviously been a theme of our legislature this year. And I think this advances that cause very nicely, very importantly.
Mr. Chairman,
Senator Limmer.
does Mr. Turner know, I see that the Met Council would be the source for funding. And on lines 1.9, it states, or starting on 1.8, each county in which a light rail transit service is operated must remit an amount to the council such that the total provided under this subdivision equals, and then it goes into detail. So I would assume this will raise property taxes in those particular cities. But Ms. Turner, am I correct in where the money comes from? Is it 100% designated from the Met Council through their taxing authority?
Mr. Turner.
Yeah, Mr. Chairman, the counties would be paying for this. And yeah, I'm not really sure of the mechanism. But there is no direct appropriation from the state to pay for this.
Right.
Mr. Chairman?
Senator Latz.
There is a fiscal note on the bill which shows no cost.
Further comments, questions? Right. See no further comments. Senator Latz moves the A27 amendment. All those in favor say aye.
Aye.
All opposed? No.
No.
Motion fails. To the A5 amendment, or, to the A5 as amended. Seen. Oh, wonderful, wonderful. Senator Latz.
Mr. Chairman, I have the A11 amendment, please.
Senator Latz moves the A511 amendment?
A11 amendment.
11,
I'm not moving the A5, Mr. Chairman.
all right. The A11. Senator Latz, to your amendment.
Mr. Chairman, there was an important omission in my judgment in the A5 Omnibus Public Safety Bill here, in that it does not take advantage of our revenue situation to increase funding for civil legal services. Civil legal services have a very high turnaway rate. They only serve 45% of the people who were eligible to be served because they did not have the resources to serve them. That said, they do serve about 92,000 Minnesotans every year. The attorneys there are the lowest paid attorneys in the public and nonprofit sectors, so they pay less than public defenders, as well as other public and nonprofit attorneys. And because of that low pay rate, they have a 39% turnover rate in 2021. So they are losing an enormous wealth of experience and knowledge and efficiency, because it takes a while to learn how to manage that kind of caseload and to learn how to handle those kinds of cases efficiently as well. So to give you an example here, the public defenders earn on average $10,000 more as starting salaries than civil legal services attorneys. So they are way underpaid, and they're providing an enormous service to people, including preventing homelessness, helping families break the cycle of domestic violence, helping seniors and people with disabilities access and understand their rights, and in their estimation, investing $1 in civil legal services returns almost $4 to the community in terms of value. They also become the portal through which many people have their only access to the judicial system. So, Mr. Chairman, it was my intent here to offer, to add a line to the budget here with a $100,000, essentially a placeholder, a dollar amount, to express the support of this committee for finding some resources in this year's budget at some point in the process to supplement civil legal services.
Mr. Chairman.
Thank you, Senator Latz. Senator Limmer.
Mr. Chairman, Mr. Turner, do you recall the increase we gave civil legal in the regular budget bill of last year?
Yes, Mr. Chairman. Last year, for fiscal year 22-23, we gave them an increase of $5,686,000, which was a 19% increase. And then for 24 and 25, the increase was $6,956,000 for a 23.6% increase in the next biennium.
Thank you, Mr. Turner. Senator Latz, considering that we've given them that much money just less than 1 year ago, I would have to be opposed to your amendment. Nearly a 23% increase in funding just last year. We can certainly revisit it in the upcoming budget discussions in the first year of biennium, but I don't know if 100,000 is really going to make a whole bit of difference when they're getting a 23%, $5 and $6 million increase.
Senator Latz.
Mr. Chairman, I know that they appreciate the increases they received, but as you can tell, they are still woefully underfunded in comparison to the need, which is not the need of civil legal services. It's the need of individuals who can't afford to hire private counsel to help them deal with issues relating to housing and domestic violence and family disputes and so on. Increasing an underfunded budget by double-digit percentages is laudable, but not enough. And so I would ask, as the, you know, if you wait a year, it's going to be a year's worth of people whose legal problems and personal problems won't be waiting for us to provide funding for civil legal services. They will suffer the consequences along the way of not having legal help. They might lose their apartment or whatever the case may be. So I would encourage the chairman, as the rest of this budget process moves forward this year, to look for a way to supplement the budget before it's too late for so many thousands of Minnesotans. If they serve 92,000 Minnesotans, and that was only 45% of the need, that means there's probably 100,000 Minnesotans out there that were eligible and that sought their services, but were not provided it due to lack of the institutional resources here. So, Mr. Chairman, with that encouragement to try to find a way to do something this year, I'm going to withdraw the A11 amendment.
Senator Latz withdraws the A11 amendment. To
Mr.
the
Chairman?
A5 as amended.
Mr. Chairman?
Senator Latz.
Mr. Chairman, I have the A18 amendment, please.
Senator Latz moves the A18 amendment. To your amendment, Senator Latz.
Mr. Chairman, there has been a lot of focus on finding ways to recruit quality police officers into our communities, and I support those efforts. In fact, that effort has been recognized by the chairman and this committee, certainly by the chairman in the A5 amendment, in supporting an increase in the budget for the Pathways to Policing program. This is a program that is proven to be successful. The State Patrol uses it. St. Louis Park, community I reside in, uses it. And other programs use it as well, not only to increase the number of police officers, but to increase the number of police officers that come from non-traditional backgrounds, which is a more fertile recruiting population or pool, but also police officers that better reflect the diversity of the communities that they will be policing, enforcing the laws in, which not only it improves the, gets you better numbers to investigate and prevent crime, but also is more likely to improve the investigatory success when members of the community who share that diverse background are willing to trust the police officers with the information they have about crimes that may have occurred in their areas. My amendment increases the A5 funding from $1 million for Pathways to Policing to $3 million. I'd ask the committee's support for that.
Thank you. Members, comments? Senator Anderson?
Mr. Chair, Mr. Turner, did we fund this last year?
Mr. Turner.
And if so, how much did we?
Yeah, I think we've been funding this since fiscal year 17 at $400,000 a year.
Mr. Turner. Senator Anderson.
And so this year would be again another 400,000?
400, excuse me, Mr. Chairman, Senator
Mr.
Anderson,
Turner.
400,000 in the base, and then the bill is carrying an extra $1 million.
Okay, thank you.
Further comments, questions?
Mr. Chair, it kind of blows up our spending limit. And so I'm concerned about that.
Very good. Thank you, Senator Limmer. Senator Latz?
Mr. Chairman, I'm going to sound a bit like a broken record here, but $1 million is 0.01%. 1/100th of a percentage point of the $9 billion surplus that Minnesota has. So I guess this bill would add a 0.02% of our $9 billion surplus to fund bringing more police, more diverse police into our communities. It may take us marginally above the $200 million soft target, hard target, not sure what to describe it as, given to this committee, but even that $200 million is only 2% of the $9 billion surplus that we have in our budget this year. So I think this would be a good vehicle to indicate to the leadership of the Senate that maybe our $200 million could use a little bit of inflation to meet some of the really important needs that I think we will all agree are there in the community. That's why there is a $1 million appropriation in the A5. We can do a better job of meeting those needs with this amendment.
Mr. Chairman?
Senator Limmer?
Mr. Chairman, I can agree with Senator Latz regarding the merit of Pathway to Policing. I think it's a great program, and we have attracted a non-traditional base of applicants into the law enforcement field, especially those minority populations that have an opportunity to get into law enforcement. Unfortunately, the dollar amount of $1 million compared to $9.2 billion, we in this committee don't have $9.2 billion to compare with. And our budget is a collection of small amounts, some a little bit bigger than others, but nevertheless, as we continue discussing this bill further, we'll have to see how we track it with the other chamber. But for now, I have instructions to keep it within a spending limit. And so, Senator Latz, I'm going to have to oppose your amendment for now.
Further comments, questions? Senator Latz renews his motion for the A18 amendment. All those in favor say aye. Aye. All opposed? No.
No.
Motion fails. The A5 as amended. Thank you. Senator Latz.
I have the A10 amendment.
Senator Latz moves the A10 amendment. Senator Latz.
Mr. Chairman, we have all agreed here, and we've heard compelling testimony on a number of occasions about how important the youth intervention programs are in Minnesota for helping to prevent crime, to intercede at-risk children, to divert them from a criminal path, to provide them with supportive services. As recently as Wednesday, we heard testimony directly from the Youth Intervention Program about the value that they bring and appreciating the $3 million that is in the A5 proposed budget here. Yet we also know that their original request to fully serve what they believe they can do in Minnesota right now, the maximum effort that they could make with adequate resources to help prevent crime would require $10 million, not $3 million. I would consider this to be among the best investments that we could make in Minnesota of our taxpayer dollars. And in fact, in the communities where youth crime is rising, and in communities where there is concern about youth crime, I'd be willing to bet they would readily trade many other proposed uses of our taxpayer revenue this year, including proposals to return those taxpayer dollars directly to the taxpayers, I would say they would readily prefer to have the money spent on proven, data-driven, effective programs to prevent youth crime, and therefore crime as they grow out of youth and into their upper teens and 20s. So the A10 Amendment provides the full $10 million to the Youth Intervention Programs, grant program in the Office of Justice Programs. And I ask the committee to support that.
Any comments, questions, members?
Mr. Chairman, for the same reasons that I just explained on the previous amendment, I'll have to oppose this amendment. However, I did want to make a comment. As we look throughout the bill, we have a little bit different priorities. We're trying to address this off-budget year, the rising violent crime in Minnesota. I know that there is a prevention element to youth intervention programming, but in order to face down the violent crime that's growing, I think we need to prioritize our funds in regards to law enforcement and get our law enforcement personnel reinvigorated due to the fact that they aren't attracting as many people into the field as possible. That's where we put our priority, and I think that's where we have to be regarding the Senate position.
Senator Latz.
If I recall correctly, Mr. Chairman, Sheriff Fletcher testified how important to him youth intervention funding was. Bill Hutton, the director of the Sheriff's Association, indicated he used to be directly involved in providing these services. And I know from my own personal experience, years ago now, I was the lawyer for the state DARE program and had a direct role interacting in a relationship between the Minnesota Attorney General's office and the Minnesota DARE Officers Association. I saw firsthand, as much as a non-sworn officer can on the administrative legal side of the program, how impactful the DARE program was to motivate individual police officers to engage directly with the community, with the youth, in preventing crime, how in some cases it reinvigorated careers where they had become callous and burned out, and provided ways to improve the safety in the communities while providing better career paths for law enforcement officers. So I think we have the opportunity this year to make game-changing investments that will pay off for decades, quite literally. If there's ever a time to make these kinds of investments, it's when we have the resources to do it, not when we don't have the resources and we're scrambling for crumbs or we're cutting programs, and then the excuse is, we just don't have the money this year. That's not a valid excuse this year. It's a matter of priorities this year. Mr. Chairman, I think if you could find an extra $50 million or so, or $75 million out of the state revenue surplus this year, you could probably fund a really, really strong bipartisan investment in crime prevention, crime investigation, crime enforcement. It would be a game-changing investment in public safety on all fronts, as well as the life and well-being of so many youth that would benefit from it. So whether you accept this or any of the other programs that we have been trying to fund today that have so far not been accepted by this committee, I think there will be more opportunities in this process yet to do so. And I really hope that the Chair Limmer will fight hard for some more room in the Senate's budget before you get to the conference table with the other body. So we can go in with a very proud position on the Senate side about how to protect the public safety and help keep our youth on the right path. So, Mr. Chairman, I would ask the committee to approve the A10.
Thank you. See no further comment. Senator Latz moves the A10 amendment. All those in favor of the A10, please indicate by saying aye.
Aye.
All opposed?
No.
Amendment fails.
Mr. Chairman,
Senator Latz.
my final amendment, Mr. Chairman, is the A28. That's not an April Fool.
Senator Latz moves the A28 amendment.
Yes.
Senator Latz, to your amendment.
And Mr. Chairman, having just essentially made my closing argument, I'm going to piggyback on that foundation to support the importance of the A28 amendment. This is a statewide public safety data infrastructure investment. We have heard some of the content of this bill, the need for this investment. It is a proposal by the Minnesota Department of Corrections to create a statewide criminal justice database. This came up most recently in the context of the testimony from Lisa Walker, who were victims of an armed home invasion. We had Ms. Walker testifying remotely at a hearing this week. And she was dismayed to have found out that the person who perpetrated that home invasion had been recently in custody and was not held, even though that person was on probation in a different county. And had the probation officer in the other county been aware of the fact that the probationer had been arrested, the PO would have had the opportunity to initiate a violation and put a probation hold on that person. So even if they couldn't get charges turned around quickly enough, the person could still be held. The technological infrastructure of the Department of Corrections is antiquated. In their own words, they are using fax machines to try to get some of their work done. They cannot find the replacement equipment anymore because what they have is so old it's simply not being manufactured anymore. The systems that they do have aren't able to talk to each other. Probation offices and community corrections offices in one county can't often find information about who's on probation in another county because they don't have a centralized system that they can access to get a lot of that information. You have, I believe, in your packet, a letter from Julie Wickland, who also testified before this committee this week in support of this particular public safety, statewide public safety database. And she states that the pretrial risk assessment instrument used to determine a person should be held prior to trial, as well as the judicial risk assessment instrument that is used to determine if a juvenile should be placed back in their community on electronic home monitoring or in out-of-home placement, is only as useful as the data that is put into it. But if we have the data residing in databases somewhere, but you can't retrieve it and you can't share it across database systems, that data is worthless. It doesn't become usable information at all when the decisions are made whether to release or hold or under what conditions to release people who are arrested for committing a crime and other uses. It also impacts our ability to make informed public policy decisions here in the legislature. In fact, Senator Ingebrigtsen earlier in today's hearing asked me about whether there was data to support one of my proposals. And I was really encouraged to hear Senator Ingebrigtsen seeking to know whether there was data to support it, because frankly, we have a lot of proposals in this A5 that are not supported by data, that the data that is in those areas does not support those proposals. But here we have the ability to make sure the data that we have is usable for us in making public policy decisions and for courts and corrections community to use in making instantaneous, very important decisions about who to release and under what conditions to release people from custody. So the numbers that are in the A28 amendment are the numbers that were requested by the Department of Corrections. And it's $12 million to initial investment, and then supplemental appropriations of $11 million and an ongoing base of $9 million. A drop in the bucket compared to the harm that will be prevented by having good, solid technological infrastructure in our corrections department. And again, this databases, technology investments are really the poor stepchild in our state budgets. And every year as we go through our budget, we take a look at these lines and say, well, we'd rather fund this instead of that because well, maybe we'll give $2 million to the data needs, or maybe we'll give nothing to the data needs because we got other stuff that is feels more imperative to us. And as a result, we keep kicking the can down the road until we get to the point where they're using fax machines, which are now 20 years out of date, to share information between agencies. If ever there was a time to take the resources and make these investments, now's the time. I'd be happy to take it away from all sorts of other proposals floating around the legislature for what to do with the money that we have available to use this legislative session. I hope the committee will agree with me and ask for your support.
Thank you, Senator Latz. Committee, any comments, questions regarding this? The A28 Amendment.
Mr. Chairman.
Senator Limmer.
Mr. Chairman, when I first reviewed this proposal from DPS, I was wondering if this was a mini version of the Fusion Center. We as a Senate proposed a Fusion Center allotment to improve it considerably last year. There was a provision in it that we added that it would require an advisory board of certain citizens, law enforcement, other personnel that would be added to it, so that the citizens could have a little glimpse, without knowing all the details, but a little glimpse of the infrastructure, what it does, and perhaps give advice to those that maintain that system. I thought it was a pretty good balance of private interests, data interests, as well as satisfying that role. However, it was unfortunate that the House majority rejected it in their bill. So, Senator Latz, all of the concern that you are representing kind of fell on deaf ears last year as well. Again, we're crowding our spending limit that I have. Worthy direction, but right now, I don't think we can do it.
Senator Matthews.
Thank you, Mr. Chair. Reading this amendment strikes me as, I think we need to know what we are buying first before we approve the money to pay for it. And I don't know what all these things are in here about improving data collection, improving data reportability, improving, designing and implementing an information sharing infrastructure. These things feel like they would need to be thoroughly vetted out before we were approving money for what this project may be. I think it's a noble goal, but I would feel more comfortable by having that worked out to know what we were paying for before approving the money to pay for it.
Thank you, Senator Matthews. Senator Latz.
Mr. Chairman, I wholeheartedly agree with Senator Matthews. And I really wish that we had had an opportunity to gather that information in the last 2 months since we started session. But the Minnesota Department of Corrections has not been invited and not been allowed to come testify in this committee this year to lay out the reasons for their requests. They have been fully prepared with all of their experts, all of their policy leadership and their political leadership to come here and to support every element of their budget. And I would say the same about the Minnesota Department of Public Safety and the same about the Minnesota Department of Human Rights. The governor has made supplemental budget proposals. None of the agencies have been allowed to come here and testify to support their requests, most of which was known before the most recent upgrade in the forecast and some formal bill introductions. I absolutely agree that we make better decisions when we have information on which to make our decisions. But we can't complain that we don't have the information when we block that information from coming to us.
Thank you, Senator Latz. Senator Kiffmeyer.
Mr. Chair, did this committee ever block an agency such as the Department of Corrections emailing us, writing out more details, explaining? I've seen lots of proposals that come with infographics, a whole bunch of things. It's a lot of money. So where's all of that? I mean, there are agencies that have the capacity and the ability to communicate that to us. I don't see why that isn't something that they're relatively able to do. Thank you, Mr. Chair.
Thank you, Senator Kiffmeyer. Senator Matthews.
Mr. Chair, to my knowledge, the Department of Corrections did not ever request a chance to meet or explain anything to me on the civil law and data practices side all session. I have sent a text to my committee administrator to ask if he ever is aware of something. I don't have a response yet. The characterization that was made is definitely not true from my end of things. So I'll leave it at that.
Thank you, Senator Matthews. Senator Limmer.
Mr. Chair, being the chairman, I have never restricted the department, any department, to come before us. I haven't heard of too many requests to come before us. I think when we presented the bill the last time we had it, we invited departments to make comment about our bill. And so I think I've talked, as far as the Department of Corrections, I think I've spent more time talking to the correction officers in the Department of Corrections more than I've talked to the commissioner this session. And he was here about, within the last 10 days, I think he gave a brief testimony. I can't really agree with you, Senator Latz, that we've blocked them or restricted them in any way.
Thank you, Senator Limmer. Senator Latz.
Mr. Chairman, it seems to me that it's an obligation of the relevant committee to reach out to the governor's administration and invite their input as to how to spend money for the money that they'll be administering on behalf of the legislative appropriations. I don't think we have to wait for the agencies to come begging for our time in a committee hearing. Nor do I think it's adequate to simply say they could have sent us an email. Emails aren't transparent to the public. A 50-page report can be dense and hard to digest. We have committee hearings. We spend a lot of time parading people through this committee in support of a half a dozen Get Tough on Crime proposals. There was more than adequate time to invite the Commissioner of Corrections or his staff to come and present why they think they should make the expenditures they're proposing in the governor's budget. I don't think it's enough to say we were waiting for them to reach out to us. I do have it from a staff person, secondhand admittedly, but a stakeholder in this area had complained to another staff person that they had sought permission to testify before this committee on Wednesday about what was not in the bill that they think should have been. And they were informed they're only taking testimony from people about what is in the bill. Now, as I say, that's secondhand. It's troubling if it's true. But this committee shouldn't be acting as a gatekeeper on public discussions. This committee should be acting as a source of information for the public to be able to evaluate all the proposals, including the proposals by the duly elected governor of the state of Minnesota, as to what's best and how to spend the $9 billion surplus to improve public safety. I mean, I certainly I understand that this committee is not going to accept the investment in technology here. As I think this committee knows, I don't always agree with my colleagues in the House either, the other body, and I supported the Senate position with regard to, I supported funding Fusion Center because of, I thought, the advantages, even though I had some concerns about, you know, some of the data capabilities that are there. But I think we're all better served by having more transparency, more information before us than less. And I think we need to double down on our efforts to make that happen, particularly from the governor and the governor's administration, the experts that he has appointed to run our agencies and spend the money that we appropriate. Thank you, Mr. Chairman.
Senator Latz, I just want to clarify one point that you brought up there as well, too, was that this secondhand person was not allowed to testify, and that may or may not be true, but anybody was able to submit letters on Wednesday when we had the open testimony. DOC, DPS, Department of Justice also submitted letters that were in your packet that brought up some of the points that you had. What we were talking about was only verbal testimony to provisions within the bill. So we want to make sure that that's clarified, that we did. And the agency did not ask to testify to Senator Limmer's bill in any respect, and they had provisions within that bill as well. So I just want to be clear on that they were welcome to submit testimony on anything that was outside the bill and welcome to come here and verbally testify to anything that was within the bill too. So they had ample opportunity to do that. Senator Latz renews his A28 amendment. See no further, yeah. So, see no further comment. Senator Latz renews his A28 amendment. All those in favor say aye. Aye. All opposed? No.
No.
Amendment fails. To the A35, the A5, I'm sorry, A5 amendment as amended. Senator Limmer, would you like to move the A5 amendment as amended?
Yes, Mr. Chair, I'll move the, it's not called the A5 anymore. It's called Senate File 2673 as amended. Be recommended to pass and move to Finance Committee.
Senator Latz.
Mr. Chairman, I appreciate the committee's work and willingness to try to find common ground where we can. A number of these provisions, I appreciate Chairman Limmer for agreeing with some of our proposals here and finding value and including them. Obviously, have some disagreements on those policies. I particularly wish Senator Limmer would maybe talk with Senator Newman and reconsider the administrative citation provisions here. I think perhaps on deeper reflection that the value in favor of public safety might be understood there with more clarity, and maybe Senator Limmer's questions could be answered more thoroughly by either Senator Newman or Senator Dibble, who is the chief author of that bill. before the legislature at this time. I'm grateful that some of our proposals will be advancing along with this bill. I've made no secret of the fact that I think the overall package is deficient in a number of ways. I'm not going to repeat any of that, but for those reasons, I regretfully have to vote no on today's A5 amendment. Thank you, Mr. Chairman.
Thank you. Further comment? All right. Senator Limmer, we're going to do a slight procedural move here. We're going to do the A5 as amended.
Okay.
First, adopt that, and then we will move the Senate File 2673 to Finance.
Mr. Chairman, I'll withdraw my previous motion.
All right. And Mr. Backus, do you need any authority within this to make technical changes going forward here?
Mr. Chair, members, I'm not quite sure I do, but it's always a good idea to give me the authority for that.
Okay. How would you like? Okay. Senator Limmer moves the A5 amendment as amended with technical authority for staff to make technical changes. All those in favor, say aye. Aye.
Aye.
All those opposed?
No.
Motion passes. Senator
Chairman?
Limmer?
Mr. Chairman, we have another bill before us.
So now Senator Limmer moves 2673 as amended to Finance.
So moved, Mr. Chair.
All those in favor, say aye.
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 Opposed? No. Motion passes. Senate File 2673 is on the way to Finance. Thank you.
Thank you.
Yep, I got that. Here's your snowstorm and sticky notes.
Senator Johnson,
Thank you, Senator Limmer.
you have Senate File 3329 before us.
Yes, Senator Limmer. So as you remember, last week, I believe it was, we had Senate File 3329, which dealt with the new technology, I think Senator Ingebrigtsen called it Batman technology, where officers are now able to propel a tracking device onto a stolen vehicle. This bill allows for that with the consent of the owner and or the owner of the motor vehicle has reported that to law enforcement the vehicle was stolen. So in those cases. And last week we had the what is labeled the A3 Amendment today. I believe we adopted that. So that limits the time limit. That tracking device could be on that vehicle without a search warrant.
So Senator Johnson, the A3 amendment has already been accepted by our committee. And members, you have that amendment in your packets. But we've already included it. So Senator Johnson, please proceed.
Thank you, Senator Limmer. So I do have one additional amendment after talking to stakeholders and House counterpart on this particular bill that deals a little bit with the concerns that law enforcement will be able to go up into somebody's yard and tag an unoccupied vehicle, which an unoccupied vehicle really is not what we're that concerned about in this. We really want to increase the public safety by tagging somebody while they're in the act, while they're driving that vehicle, to reduce the chances of police chase that would really impact public safety up and down the roads. Mr. Chair, I would move the A6 amendment.
Senator Johnson moves the A6 amendment. Let's open it up for discussion. Members? Senator Lance.
Mr. Chairman, I've got an idea about that I think might be a better way to approach this problem that I think we all agree needs to be solved. I'm not sure procedurally what the best point in the process is here for me to offer my proposed solution. I think maybe what I will do is I will wait until after the bill is in the shape that the author would prefer us to consider it on the merits, and then I'm going to offer a wholesale alternative to that approach.
In the form of an amendment?
Yes.
All right. Is that okay with you, Senator
That would be fine.
Johnson?
Yes.
All right. Senator Johnson, why don't we proceed with your amendment? Is there anyone in the audience who wishes to speak for or against the A6 amendment? Hearing none, are there any, please proceed to the table. Yeah. This is a different.
Mr. Chair Limmer, since you offered.
Please identify yourself for the
My
record.
record is Rich Newmeister. Since you offered the opportunity, I took advantage of it, if I may. I
Proceed.
think, Chair Limmer, the discussion, I'm aware of Senator Lance's proposal. I think that has merit for this committee to discuss. If that is not done, I would like to suggest language on the amendment, which, if you remember, I don't have the bill in front of me, where there's a second provision that says the owner of the motor vehicle has reported to law enforcement that a vehicle is stolen, which is documented. So I want to be sure that a motor vehicle that has been reported to law enforcement, it is documented, so that someone can go back and sort of say, where did you get this? Is it, was there a report or whatever it might be? Because the way to is the owner of the motor vehicle has reported to law enforcement that the vehicle is stolen is what sets the ability to put the locator on. So that would be my suggested language, or some variation like that. Senator Chair Limmer, members of the committee, thank you very much.
Thank you, Mr. Newmeister.
Thank you.
Yes, Senator Matthews.
Thank you, Mr. Chair. So just a question either for Senator Johnson or council. Then if I'm reading this correctly, you're further limiting this to apply a tracking device in two scenarios. Number one would be full consent to the owner being obtained, which I think we've all been in agreement with. And the second avenue to do it would be if a vehicle is reported stolen and, oh, I'm reading occupied, my brain went to like it's moving down the road essentially. I guess maybe if Senator Johnson would clarify what this second line, the modified language would do in effect. Occupied, I would assume, meaning if they're going down the highway and they spot this vehicle that's been reported stolen, then the Batmobile fires this tracker on the moving vehicle down the highway to try to find it. But if it says occupied, can a vehicle be considered occupied while it's, if people are in it, stationary in a driveway or at a stop sign or what have it? So if maybe Senator Johnson would explain a little further.
Senator Johnson.
Certainly. Thank you, Mr. Chair and Senator Matthews. Yeah, the idea behind it is that you're not going to surreptitiously come up and tag somebody's vehicle necessarily without them being in it. In that case, you know, you're thinking of you need a search warrant or something like that that would be to go onto somebody's property and do that. This just makes it more clear that it's more about the public safety aspect, the potential of a pursuit, those sorts of things that would come up. And that's why we said, you know, limited to occupied, so you're not coming in the dead of night and shooting somebody's vehicle, even though it has been reported stolen or that you have the consent of the owner. This still gives the vehicle owner or those that are affected by this another level of privacy going forward. So that's the idea behind the amendment.
Any other discussion? Senator Bingham.
Thank you, Mr. Chair. Senator Johnson, thank you for bringing this amendment forward. I think this further gets at the concerns of the committee because you still have that 24-hour limitation, and now you have this. So I think the two greatest concerns that this committee brought up earlier or last week, sorry, they're blending together. The two amendments that have been adopted, I think really do get at the concerns. So I appreciate Senator Johnson working on this to fine tune it.
Okay. Hearing no further discussion, all those in favor of the A6 amendment, say aye. Aye. Opposed?
Aye.
The amendment is adopted. Thank you, Senator Johnson.
Thank you.
Now, Senator Latz.
Thank you, Mr. Chairman. First, I'd like if Mr. Backus could give us an idea of what the case law is surrounding the use of the standards for attaching tracking devices and how it relates to probable cause.
Mr. Backus.
Mr. Chair, members, my understanding is that it's a bit of an odd situation in that in Minnesota, we have the statute 626A.35 to 39, I think it is, where anyone who wants to put a mobile tracking device on I guess, property has to get a court order under those sections. And the court order is based on reason to believe that the information is likely to be obtained by the installation and use is relevant to an ongoing criminal investigation. So technically in the statute, law enforcement doesn't need to seek a search warrant for, say, putting a tracking device on a car. However, there's Supreme Court and other case law that does indicate that, for the most part, that is considered a search, and that therefore law enforcement would either have to get a search warrant or there'd have to be an exception to the search warrant requirement, for example, consent or exigent circumstances. So, you know, it's just a little bit of an odd situation there. You know, of course, that's not in any statute, that's just under case law. And then the question becomes, well, what about say a stolen motor vehicle, as in this case, in which case you'd have to look, does the person occupying it have a reasonable expectation of privacy, in which case is it a search, things like that. So I'm not sure if that answers the question, but I guess for, I think it's the US v. Jones case from 2012, which held that, when law enforcement puts, say, a tracking device on a vehicle and then uses it to track, at least, I think in that case, it was for almost a month, that would require a search warrant. So in this case, the statute at issue in this bill is 626A.35, which again is not really the search warrant law. It's the court order for a tracking device, which again is not based on probable cause.
Clear left.
So, Mr. Chairman, Mr. Backus, would you agree then that the statute has kind of an uncomfortable overlay, if not perhaps some inconsistencies or conflicts with the existing case law?
Mr. Chairman, members, I think for certain instances, it probably does. I mean, again, for example, if law enforcement wanted to put, say, a tracking device on my car, I believe they would need a search warrant under case law. However, again, for a stolen car, I think it would depend on the circumstances. I would think that probably wouldn't be the case because I don't think a person would generally have a reasonable expectation of privacy in a stolen car. But we do have the statute that provides for a gross misdemeanor penalty for anybody who puts a tracking device on, say, a car in this instance without going through the process in 626A, which again requires going to the court for this order, which is not really a search warrant. So there is a bit of an inconsistency there as far as I can see.
So,
Clear left.
Mr. Chairman, it sounds like what we have is a case law situation where it's highly unlikely that a law enforcement officer under constitutional law would need to do anything to put a tracking device on a stolen vehicle. They see it, they could attach it, just like that, because there's no Fourth Amendment implication or protections for a stolen vehicle. Yet we've got a statute that overlays that frankly imposes a separate set of requirements on a police officer, regardless of what the Constitution has to say or constitutional law requires. And that's what creates the conflict that brings us to the table here today to try to solve, right? The only thing right now standing between a police officer and attaching a tracking device to a stolen vehicle is the statute itself that says they can't do it without getting a court order first. So now we're here trying to fashion language in this constricting statute that will create an exception to the required court order that is not overbroad and is not too narrow, so that in all the right circumstances, the officers can attach a tracking device, and all the wrong circumstances, they can't attach a tracking device. When the vehicle is parked, they won't be able to do it because it can only be on a moving vehicle. They can't track it for longer than 24 hours. Whatever the other requirements are that are in the proposed amendments. We aren't putting an amendment in there that says there's an exigent circumstances exception to the statutory requirement, although that might have been another alternative. So I think it probably wouldn't take too long for us to spin out hypotheticals where the language that is proposed here in the bill might be overbroad or might be underbroad under whatever particular circumstances there are. For example, I think I'm trying to find the exact language here. Does the vehicle have to have been reported as stolen? So how does the officer respond to a vehicle that they don't have reported as stolen, but which appears to be fleeing in a motor vehicle after the officer attempts to initiate a traffic stop? It's a felony offense. Is that an exigent circumstance? Doesn't really matter if it's an exigent circumstance under Fourth Amendment jurisprudence, because under the statute, they would still have to go get a court order before they could attach the GPS tracking device. Yet I, as a citizen, would want them to be able to attach the tracking device right away. Because if whatever time it takes to get the court order, the vehicle's gone. Who knows why they were fleeing? Maybe they were just scared of cops, or maybe they had contraband in the vehicle. We've heard a lot about the proposals that there's a value in stopping vehicles for whatever reason, on the, whatever percentage of a chance it is that you're gonna find a firearm or drugs or whatever in the vehicle. If you've got that in the vehicle, you might take your chance on fleeing. You're already gonna face a felony, so might as well felony flee as well, and then you're endangering other people on the road, and you're raising all the issues around a chase. And so how do you fashion these exceptions or the statute to make sure you're getting the ones you want to be able to get with the tracking device and you don't get the ones you don't want to get? My proposal is to just eliminate the statutory issues altogether. And for that, I would offer the A7 Amendment.
Mr. Chair,
Senator Johnson.
I think just moments ago, Senator Latz said that he had offered his last amendment for the day, so I think he's limited.
Oh,
You're out of order, Senator Latz.
Did I say for the day or just on that bill?
We better go back and check the record.
Do you have an A7 amendment? Pass out, Senator Latz?
I thought it was being passed out, and we
Can
have it to pass out.
I mean, Mr. Backus.
And Mr. Chair, members, I've emailed it to the committee as well.
Thank you.
Mr. Chair.
Senator Anderson.
Mr. Chair, if a citizen calls the cops and says his car's been stolen, and the police go after the proposed, based on the license plate and the make and color of the car, but because they have no jurisdiction in another county, they have to stop at that county, can the citizen go after his own car without, I mean, if he basically, when the sheriff told him that they couldn't go after the car because the jurisdiction ended, he told the police or the sheriff, well, then I'm going after the car myself.
Senator Latz.
Mr. Chairman, I happen to know the answer to that under criminal law. If it's a law enforcement officer that's acting in the course and scope of his or her employment, they are allowed to follow a vehicle out of their jurisdiction into a neighboring jurisdiction or wherever they need to continue to try to apprehend the suspect. Even if they cross out of Hennepin County and go into Anoka County, they can still do that. Under some circumstances, their powers get shifted to that of a citizen who would be making a citizen arrest. But basically, they've got all the authority they need to continue the chase.
Well, Mr. Chair, Senator Latz, the owner told the sheriff that he was going after his car, and the sheriff says, well, I don't want you to go. Where are you headed for? He says, North Minneapolis. So they sent a deputy sheriff along with them, and he found the car in North Minneapolis as they were changing off the license plates off of his car. And they waited until the plates had been exchanged, and the gentleman or the individuals went into the house. He went, because he had a spare key at home, brought it with him. He got in his car and drove back home with this car. So I just, some of these things are crazy.
They tracked it because there was a mobile tracking device.
You must have left a phone in the car.
Senator Johnson.
Senator Limmer, I do appreciate the sentiment of this, and you know, this strips it back down to the constitutional basics of what a peace officer would be able to do. You know, the thing that I do like about the current state of the Senate File 3229 as amended is that it puts on a little bit more of the guardrails for protecting that the vehicle owners and those involved with the vehicle, here it seems to be fairly wide open as to what a peace officer may be able to do with the tracking device. With ours, with the bill the way that it's standing right now, there has to be some pretty specific conditions that are applied to that. So although constitutionality narrows down to a degree what the government can do, we can always become more strict on those parameters of what the government is allowed to do with those tracking devices. And this does, the current way that it is written with the amendments, very narrowly tailors what peace officers, police are able to do, law enforcement is able to do with those tracking devices. And I think it has a lot more protections for the public in this state. So I would personally, as right now looking at it, oppose the A7 amendment. However, I will ask Senator Latz, have you had any input from law enforcement on the A7 amendment as it's written?
Senator Latz.
Mr. Chairman, I don't want to misspeak here, but I believe that Sheriff Fletcher indicated to me he preferred the approach that I'm recommending. But I don't want to be accused of mischaracterizing that if I remember incorrectly.
Sure.
I guess I would just reiterate what the amendment does is it simply does not apply that statutory court order requirement for the use of tracking devices when it's used by a peace officer. So then it's just the constitutional restrictions that apply. That would enable the peace officer to attach a tracking device to a car that's not reported stolen but is appearing to flee. Not every vehicle that flees has been reported stolen first. In fact, I don't know, maybe the majority haven't. We could probably sit here and spin other hypotheticals too that would not be covered by the statutory proposal in the bill right now. One of the values of doing it in the way I propose in the A7 amendment is it would allow in the ordinary course of constitutional jurisprudence and criminal prosecutions for the cases to be sorted out by the courts on a case-by-case basis as the facts warrant and as the case law requires or develops to require. Rather than having us come back every year to say, well, here's a situation we didn't think of before, we missed it, now we want to make sure that a tracking device can be used for this purpose. That's a little bit slow, and you'll end up having vehicles out there that a tracking device would have been really helpful to catch that will get away because the officers don't want to risk a gross misdemeanor criminal penalty or a fine by doing it wrong. At least in the constitutional violation, the remedy isn't put the cop in jail. The remedy, if it's wrong, is to suppress the evidence and maybe let the defendant go free. But at least you've had the chance to try to catch the defendant, or the suspect, and bring criminal process to bear, which you wouldn't in some cases if you adopt the bill as is before us without my amendment.
Senator Latz.
Senator Latz, you made mention of Ramsey County Sheriff perhaps giving you a direction. I see that there's an official from Ramsey County. I don't know if he's prepared to give a comment about that, but.
Now he's going to tell me I made the whole thing up and I was just a planted memory of some sort.
I don't think he would do that. I might, but.
Touche.
Hey, how are you doing? Good to see you. Thanks for coming.
Would you identify yourself for the record and then proceed with your?
Yes, Chair. My name is David Titus. I'm an inspector for the Ramsey County Sheriff's Office. I believe this is completely made up. Just kidding.
April Fools, yeah.
Punch you in the committee, that's good.
Chair, the last word that I had was I believe it was the A5 Amendment was accepted, the unauthorized, or excuse me.
So that's the Senator Latz amendment. Here's the.
The unoccupied
Yep.
amendment was the last instruction that I had by the sheriff that he approved.
And what number amendment is that?
That was the A3, right? Was
We
that
adopted.
One that was already,
That's the A6 with the vehicle is occupied when the tracking device is installed.
correct.
Okay, yep.
Yeah, Senator Latz introduced the A7 as a, was it the I thought it was A7, Senator Latz.
Senator Barnes.
A7. Senator Latz is the A7, which is alternative to what we have so far.
Correct. I have not been advised on that.
All right.
Mr.
Mr. Chair? Mr. Chair?
Who's that?
Senator Ingebrigtsen?
Senator Ingebrigtsen.
Thank you, Mr. Chair.
Forgot about him.
Yeah.
Oh, I'm still here.
I guess he's here.
So Senator Latz, the question to Senator Latz, if I could, so to understand this actually gives the officers more of an ability to legally
Yes.
throw that tracking device on just a car that's being chased and won't stop. I would think the officers would think this is a very good tool because once again, you don't know what they're running from. You don't know if they're running from a domestic abuse that was violent or the trunk is loaded with some contraband. So it seems to me, if I'm understanding that correctly, this would be a real good tool for law enforcement. There would be no time for, of course, any permission from anybody, or nor need of a search warrant, I would think, or wouldn't think rather. So I think if I'm explaining this properly, I would say it would be a real positive amendment.
Senator Ingebrigtsen, what amendment are you referring to? By number?
Are you there?
Yes, what amendment were you speaking for?
Well, I was speaking of Senator Latz's amendment to the bill. Unless I'm not understanding it properly.
All right, thank you. Senator Bigham?
Thank you, Mr. Chair. I also oppose the amendment for the same reason. This is, I think, just very subjective and overly broad. I think what Senator Johnson has done to put parameters around the time, the 24 hours, the unoccupied prohibition, I think are more than enough and would support the bill that Senator Johnson has in the shape that he would like it.
Senator Limmer,
Senator Johnson.
I was going to ask Senator Latz a question here too. So just looking at this as well, I know that you say you have the opportunity then, Senator Latz, to, if a vehicle looks, like it's going to be running, or you have that opportunity to get kind of the jump on it at the very initial phases of a possible chase or whatever too, but couldn't that also be used as a pretext for putting this on? And, I thought that was going to happen. It looked like this as well. And that's one of the things that I know that we've been trying to be very careful about is eliminating those opportunities of a pretextual stop. And this would be almost a pretextual sort of a tracing issue. Just looking at the language of the bill, it kind of opens it up a little bit to that aspect. Could you just talk to that point as well?
Senator Latz.
So, Mr. Chairman, Senator Johnson, I agree with you that that's a risk. We ought to be concerned, and I'm concerned about pretextual use of law enforcement tools as well. I would say I don't know what Ramsey County has off the top of my head, but most law enforcement agencies now have dash cameras in their squad cars. So it's quite, in most cases, you can see the video evidence of what led to a stop. I mean, if you're watching a dash camera in the vehicle, you turn the lights on, and most of these cameras are tied into the systems in the squad cars, so you can tell on the camera when the emergency lights go on, for example, to initiate a stop. And you can watch to see whether the car in front of them slows down, pulls over, speeds up, takes off. So you're not simply relying on the word of the officer. You've got the video evidence that would be able to back that up or not back that up, which frankly also has the benefit of holding the officer more accountable to making sure that they've got a lawful basis for initiating the stop. At least with regard to fleeing, I mean, under the law, basically any driving behavior other than stopping immediately upon a show of force, or of authority rather, is felony fleeing. If they make a quick right turn into the next street after the emergency lights are turned on, that would be considered felony fleeing. If you see them accelerate away, that's felony fleeing. Any kind of evasive behavior at all is felony fleeing. Even just failing to stop, there's some uncertainty about whether that's not obeying a lawful order or whether that's felony fleeing. So I would think the risk of a pretextual attachment of a GPS tracking device to a moving vehicle is fairly low when you probably have video evidence that would be able to document one way or the other. I'm comfortable with the Fourth Amendment protection on that. You know, I think where you really end up in the pretext situation is when there is otherwise an articulable lawful basis for the stop of the vehicle, but that's not the real purpose of the stop. You know, they're going 5 miles over the speed limit and you can document that. Yeah, you've got a lawful basis for stopping them, but that the real reason, okay, here, the worst case scenario, right? The real reason you're stopping them is because they're black and not because they're speeding. Okay, that's sort of the classic allegation of pretextual stops, right? And that a video camera isn't going to help you solve. You still have that problem, you know, almost any kind of a stop situation. But you're right. I mean, the proposal in your bill, Senator Johnson, does create more restrictions in that regard. How likely is it to be abused for that purpose? You know, that's one of those hard things to say.
Senator Johnson?
Thank you, Senator Limmer. So as to the A7 Latz Amendment that we're currently on, I do understand the purpose and the point of that. However, I do like the work that Representative Moeller and others have done in narrowing this down. We've worked together on getting that language. I think we've got the right mix of guardrails. If that doesn't turn out to be right, we can always come back and adjust on that right now. But I think this simply opens it up, the A7 Amendment opens it up a little bit further than what I'm comfortable with. Committee members and Mr. Chair, I would oppose that at this point.
Mr. Newmeister?
Chair Limmer, members of the committee, listening to the perspective, and yes, I knew it would broaden. I would rather be predictive what we know to protect our rights. So even though, you know, how A5 is there, you decide what you decide. I'd rather stick with this and Senator Latz's proposal. One of the things that this committee can do and others is have some oversight hearings, and the Privacy Commission, whatever. How are these being used? How easy is it to put a mobile tracking device on a car? If a police officer decides to put a mobile tracking device on a car, stationary, without a warrant or anything, keep it on for 12 hours, takes it off, the individual may never know about it, but the police will know about it. So one of the things that this, at least the misdemeanor deal, you know, that penalty, it prevents at least that kind of behavior currently now for cops being able to do that. Because if they get caught, they get sanctioned with this. So there is, as Senator Lance indicated, Chair Limmer, there are some unknowns. So that's my perspective on that. I would say, even though I disagree the direction, I'd like a little bit more, but I know you don't get everything you get in this process. At least what Senator Bingham and Senator Johnson are heading for is better than the A7. Thank you, Mr.
Thank you. Is there any further discussion regarding Senate File 3329?
It's Senator Limmer, Mr. Chair.
Senator Johnson?
I would like to say, I just got a note that Senator Fletcher
That's
agrees.
Sheriff Fletcher.
What's that?
That's Sheriff Fletcher.
Oh, Sheriff Fletcher.
We don't want to
The
demote
handwriting,
him
it was the handwriting.
anymore.
He agrees with original language plus the unoccupied vehicle amendment in the A6, so
All right,
just an update. I don't think he'd given an opinion quite yet on that, so
okay,
this is the official,
all right.
for what it's worth.
Could you repeat that for the benefit of Senator Latz?
I think, Mr. Chair, Senator Latz probably just heard the same. You're okay. Sheriff Fletcher agrees with original language plus the unoccupied vehicle amendment in the A6.
All right. Senator Latz?
Mr. Chairman, that's what I was just informed as well, so my memory must have been off. I apologize. Or else he's changed his thinking on it since I spoke with him last, as he has consulted with other individuals.
Okay.
But I would just note for the record then that under the current proposal, law enforcement will not be able to attack a tracking device to a fleeing vehicle unless the vehicle has first been reported stolen. I'm not comfortable with that. So I'm going to ask to have a vote on the A7 amendment.
All right.
Mr. Chair,
Senator Ingebrigtsen?
I agree. Mr. Chair, I agree with Senator Latz. I'm not sure that Sheriff Fletcher understands what the amendment is, but that fleeing car could be a stolen car. You just never know, and you have to put, again, trust in law enforcement. If they're going to put something on something that isn't fleeing, they're still going to have to answer for that. They're still going to have to come up with probable cause for whatever reason they put that on that car. You know, I mean, there has to be some latitude out there. However, if you got a screaming car running away from you, really, what's the difference here? What's really the difference between whether it's reported stolen or he's just fleeing because he's an unlicensed driver or he's a, you know, somebody on probation, whatever. The point is you want to be able to track them so you don't have to chase them. So I agree with Senator Latz. I would hope for reconsideration of this because I think this is a good tool. And again, knowing that the officers have to be responsible for what they're doing.
All right. Senator Latz has moved the A7 amendment. It's before us. Any further discussion? Hearing none. All those in favor, say aye.
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 Aye. Opposed?
No.
I believe the amendment is not adopted.
Division.
Division's called for. All those in favor of the A7 amendment, raise your hand. And Senator Ingebrigtsen is raising his hand, I'm assuming. That's-
Yes, I am.
And opposed? 2, 3, 4, 5. The amendment is not adopted. We now have the Senate File 3329 as amended. Before us, Senator Matthews.
Quick question for Senator Johnson. I know there's been talk behind the scenes about the 24 hours language, and I know discussions have been had as to whether it would make sense to change that to 12. That was not in the amendments we brought today. I'm wondering if you have an opinion on that, if you're open to that, or if that was intentional.
Yes, Mr. Chair.
Senator Johnson.
Senator Matthews, we did discuss that when law enforcement was here talking about this precise part of the bill with that amendment was brought forward by the ACLU. 24 hours was a comfortable time to be able to get any sort of judicial document to support that tracking device on there. It gave it ample time for that, and yet it didn't seem to be such a long time that you'd be, you know, for a month or a week or anything like that, where you'd be developing the investigation and the probable cause or anything like that. So this gives you that time to actually work within there with the judicial center or judge to get your search warrant or whatever you might need at that point. So we did talk about it. 12 hours seemed to bring it into a very, very tight time frame. It seemed like folks were able to work within that.
Any further discussion? Senator Latz.
Mr. Chairman, I think the bill that we now have before us is better than not making any changes to the statute at all, so I'm going to support it. But I will note that once the 24 hours have expired, and even if the officers get a search warrant, a court order that they can continue tracking the device or the vehicle with a GPS device, they're still going to be in violation of this statute now, unless they also separately get a court order authorizing it under the statute. So the officers are going to have to get 2 court orders, 1 search warrant under the 4th Amendment and 1 court order under this statute to continue tracking beyond 24 hours if they haven't been able to obtain possession of the vehicle. Gets a little complicated that way.
Thank you, Senator Latz. We have the bill before us. Senator Johnson, I don't believe there's anyone in the audience who wishes to speak for or against this bill.
No further comments, Mr. Chair.
Senator Johnson moves Senate File 3329 as amended be recommended to pass and move to the floor.
General orders. Yeah.
Hearing no further discussion, all those in favor say aye.
Aye.
Opposed? The motion prevails. Thank you, Senator Johnson. Before we leave, folks, I think we owe our staff a tremendous amount of thanks for all the work they've done. And they've done a tremendous amount of work. They roll with us, whether they want to go home or not. They're stuck here with us, and they're a tremendous help, and I compliment them for putting up with us all. But want to thank them. This may not be our last meeting because we have talked about a few late bills that might float back to us. But I thought I'd get the thanks in for our staff anyway. So I don't believe there's any further business before our committee, so we stand adjourned. Thank you all.
Thank you.